Thank you.
Is everybody ready? Thank you. This is the matter of the Chinese Association Gauteng, TCA, versus Alice Henning and 11 others, case number EQ 2-2017.
May it please the court, my lord, I appear on behalf of the complainant, the Chinese Association Gauteng. I'm ably assisted by my learned friends and juniors, Mr. Ben Winks, Miss Kathleen Hardy, and Miss Kerry Williams. We are instructed by Namford Inc. by Miss Joyce Namford.
Thank you.
As the court pleases, my lord, I appear on behalf of the 4th and 8th respondents, and I'm instructed by Otto Krause Incorporated.
Thank you. Yes, gentlemen, thank you very much. Have you finished, Advocate Garvey?
As the court pleases, my lord.
Okay, thank you so about that. Thank you, gentlemen. Gentlemen, I have received your heads of argument, and I've gone through both. I'm not sure you're ready to start. Or is there anything that you wanted to point out first? Thank you.
Thank you, Justice Makume. Thank you, Justice Makume. Before we commence in earnest with our oral submissions, just two matters of housekeeping I'd like to bring to your attention and clear up very briefly. The first concerns the documents and files before you, and the second concerns the complainant's right of reply. If I might, I'd like to deal with both of them very briefly. I just wish to confirm in relation to the question of documents and files what serves before you, because things can get a little hairy with the number of documents floating about. Can I trouble you to indicate to us, Justice Makume, whether you have the following in your possession? Firstly, a pleadings bundle. Secondly, a notices bundle. Thirdly, a trial bundle comprising at least 2 parts.
Yes.
Fourthly, a witnesses bundle, the complainant's witness statements bundle.
Yes.
Fifthly, a transcripts bundle, which comprises all of the transcripts of the 13 days of the hearing in chronological format, numbered from page 1 to page 1875. And finally, the complainant's heads, as well as its indexed paginated authorities bundle and the respondent's heads. Can I just, with respect, get your confirmation that you have those before you, Justice Makume?
Yes, Counsel, let me cautiously say that I've been working from home. My files are not in chronological order, but I have come across most of the documents and files that you mentioned. I can see them on my desk here. Anytime that I seem to be missing something, I go back to my chambers and look whether the file is lying around somewhere. And yeah, I can confirm that documents that you mentioned, I can see the files here before me, and especially that the full transcript is now before me. It has been uploaded on that I have. And the complainants as well as the respondents' sets of argument are before me. Yes.
Thank you for that indication, Justice Makume. If there is anything that you require or any assistance you require in relation to missing documents, please feel free to request, and I'm sure between the parties we'll be able to assist you in that regard.
Thank you.
All right. The second question I'd like to broach with you right at the outset as a matter of housekeeping concerns the complainant's right of reply. You will have been furnished with a letter dated 6 December 2021, together with a series of supporting annexures, which comprise earlier correspondence. That letter is from Namford Incorporated. It is addressed to Otto Krause is the attorneys for the 4th and 8th respondents. The letter essentially points out that the 4th and 8th respondents have filed their heads more than 2 months out of time in contravention of this court's directive, and notwithstanding at least 6 reminders from Namford Incorporated, as well as the judge's second letter confirming the date by which they were to file their heads. Their heads were due on 24 September 2021. They only filed it more than 2 months later, as I say, on 30 November 2021. The complainant would have had an opportunity to file its reply 3 weeks later on 8 October 2021, as per this court's directive. Because of the late filing of the heads by the 4th and 8th respondents, the complainant's opportunity to file a reply has been effectively rendered nugatory. I should add that the 4th and 8th respondents have brought no application for condonation. They have simply ridden roughshod over the court's directive, not for the first time, and they have filed their heads. There is accordingly no explanation whatsoever on the correspondence or on oath in a condonation application for the late filing of the heads. We don't mean to make something excessive of it. We are not suggesting that their heads should be disregarded. We are pointing out their conduct, and we are pointing out that we've been prejudiced thereby. What we propose going forward, therefore, Justice Makume, to assist both yourself and to facilitate the complainant properly having its right of reply, we propose that we produce our reply within 10 days after the date of this hearing. That will deal with the arguments foreshadowed in Mr. Garvey's heads of argument, as well as in the course of the submissions today. It will no doubt provide better and more detailed assistance to the court. We are, however, in your hands in that regard, Justice Makume. We can see no prejudice occasion to any party. It can only assist the court, and it certainly doesn't lie in the 4th and 8th respondents' mouth to try and oppose it or get a further bite at the cherry.
Thank you. Perhaps let's give an opportunity to Advocate Garvey to respond to the late filing of the heads and the reasons why no condemnation was applied for, and what were the problems. Advocate Garvey.
As the court pleases, my lord, your lordship broke up, but if I understood from what I heard your lordship saying, my submission is that we have no difficulty with the suggestion by Mr. Ismail.
You have no difficulty with that?
As the court pleases, my lord.
All right. Well, can we then maybe just for record purposes find out the reasons why the respondents did not comply with the directive and the agreement to file heads during September? What were the problems? There could have been reasons why the heads were not filed. That's what we want to know. I want to know.
My lord, in that regard, if your lordship wants full reasons, I can just say that my instructor, I did the heads according to my instructions. I will not say that I wasn't under a lot of work pressure at the time, and that may have attributed to it, but I can get full instructions and we can make a submission in writing to your lordship in that regard after the hearing of this matter within X days in the new year. I don't think I'm going to be available after today, and I believe Mr. Krause is also not available after today, so we can provide your lordship with some written reasons as to that fact. There was also, as I understand it, some difficulties in getting instructions from, in particular, the 4th respondent, And I think that contributed as well, my lord. But I can't take it at this stage any further than that, as the court pleases.
Very well then. As I understand it, Advocate Garvey has got no problem with the proposal by Advocate Ismail that they be given opportunity to file their reply to your heads. Then we need to have a fuller picture as to their responses to your heads of argument. And then secondly, that you will then, the respondent will then also furnish me with reasons or affidavits by attorneys for the fourth and eighth respondent as to the reasons why the heads were filed late in this matter. Am I correct, Advocate Ismail? Can we then proceed on that basis?
Thank you, Justice Makume.
Thank you very much. Very well then, we can proceed, Advocate Ismail.
Much appreciated. If we could now turn to our heads of argument.
Yes.
If you have that document before you, Justice Makume, I'll be going through it. At the outset, I'd like to apologize. The heads are lengthy and detailed, but we thought we would err on the side of caution and inclusivity, providing you as detailed and comprehensive a picture as possible in the circumstances. We hope that that will provide assistance rather than operate as a hindrance to the court. As I go through the heads, Justice Makume, and as my learned juniors do so as well, we are going to highlight particular aspects for the court's attention. To the extent we do not deal with anything contained in the heads, we are not by any means abandoning the argument. On the contrary, we persist with our argument as set out in all of the submissions in the heads. We are simply highlighting certain aspects for the court's benefit. I'd like to start out with an introduction to this matter. I'd like to point out three things. By way of overview, they're as follows. First, words are incredibly powerful. They matter. Secondly, social media platforms like Facebook can be forces for considerable wickedness, spreading hate speech, if not dealt with appropriately and carefully. Their potential for causing hurt and damage and engendering violence is limitless. And thirdly, I want to highlight some of the background of this complaint. To the first point then, it is trite that words convey meaning and they do cause hurt and injury. That much has been set out in numerous cases, many of which have been cited in our heads. Words can in fact amount to hate speech, harassment, and unfair discrimination under the Act. I'm referring to the Promotion of Equality and Prevention of Unfair Discrimination Act of number 4 of 2000, simply by the shorthand as the Act. It's less of a mouthful. Most recently in the Constitutional Court decision in Quilani, the unanimous court per Majid J held as follows. Speech is powerful. It has the ability to build, promote, and nurture, but it can also denigrate, humiliate, and destroy. Hate speech is one of the most devastating modes of subverting the dignity and self-worth of human beings. This is so because hate speech marginalizes and delegitimizes individuals based on their membership of a group. This may diminish their social standing in the broader society outside of the group they identify with and can ignite exclusion, hostility, discrimination, and violence against them. Not only does it wound the individuals who share the group identity or this group identity, but it seeks to undo the very fabric of our society as envisaged in our Constitution. The complainant, Justice Makume, the TCA, acts on behalf of a broad community of people of Chinese race living in South Africa. It's mandated to represent dozens of associations and organizations of Chinese persons in South Africa. They represent not only migrants from abroad who've recently arrived on these shores, but many thousands of Chinese people born here with South African roots reaching back as far as 4 or 5 generations. In February 2017, this community of Chinese people was besieged by a torrent of hateful words published by fellow South Africans on the internet. These words demonized them, dehumanized them, incited harm against them as the Chinese people, as a racial group. The comments numbered in the hundreds, if not thousands. They included comments by the 12 respondents in this case. This case is a watershed in that it's the first time in their history that Chinese South Africans have resolved to challenge the use of these hateful words, to affirm their right to dignity and equality under South African law, and to approach this equality court in order to do so. The second point I want to deal with under the introduction concerns this notion of Facebook and social media as a facilitator of hate speech. This case in particular concerns words published on the internet on the most popular social media platform, Facebook. Such social media platforms are highly popular. They have distinct features that make it especially dangerous in facilitating hate speech as compared, for example, to traditional media such as newspapers, radio, and television. They are instantly accessible. They are more widely accessible, and critically, they are accessible to children and youth. In 2019, the United Nations Secretary General Antonio Guterres highlighted social media as one of the key instruments of contemporary hate speech. He said, "Around the world, we are seeing a disturbing groundswell of xenophobia, racism, and intolerance. Social media and other forms of communication are being exploited as platforms for bigotry. Hate is moving into the mainstream in liberal democracies and authoritarian systems alike. And with each broken norm, the pillars of our common humanity are weakened." In New Zealand, you will recall, Justice Makume, that in March 2019, a white supremacist used Facebook to live broadcast himself gunning down 100 worshippers at a mosque. The New Zealand Prime Minister, Jacinda Ardern, addressed Parliament after that Christchurch mosque massacre. She confronted the menace of social media hate speech. This is what she said to Parliament. "Safety means being free from the fear of violence, but it also means being free from the fear of those sentiments of racism and hate that create a place where violence can flourish. That sentiment is extremely apposite in the present case, Justice Makume." The following day, Jacinda Ardern addressed a high school which had lost 2 students in that Christchurch massacre. She again touched on the theme of social media and hate speech. This is what she had to say. And I'm at paragraph 13 of our heads for reference, Justice Makume. She said, "Social media can be a place where we can do good. It can also be a place where hate and division are spread. There are lots of things that governments can do to make sure people are free from violence, and we will do those things. But it also means making a place where there is no environment for violence to flourish, where we don't let racism exist, because racism breeds extremism." Now, what has our government done to counter this racist sentiment that can flourish on these great facilitating platforms such as social media, including on Facebook? Well, through the legislature, we have promulgated the Act. And this is what this case is about, ensuring that online-based social media, that is on the internet, in particular in this case Facebook, is a safe place or environment where there is no hope for hatred and racism and ultimately violence to flourish. That is really what this Act is aimed at, Justice Makume, and what this case is about. Now that brings us to the third leg of the introduction, this complaint. It is common cause that on Saturday, 28 January 2017, the South African Chinese community celebrated the Chinese New Year. The day thereafter, the television program Carte Blanche aired a documentary about the inhumane slaughter of donkeys in South Africa, allegedly for the use of their hides in traditional Chinese medicine. Although the perpetrators of the slaughter visually depicted in the documentary were of all races other than Chinese, hundreds of South Africans responded to the program by directing racist insults, stereotypes, tropes, and even incitements to violence and ethnic cleansing against people of Chinese race generally, and especially those living in South Africa. Within days of this torrent of abuse, the TCA convened a special general meeting of multiple associations across the country that collectively represent more than 100,000 Chinese people who call South Africa home, and they were mandated, the TCA, Can you hear me now, Justice Makume?
Yeah, there was a problem. Couldn't hear you.
I think I was accidentally muted by the host.
Yes, you were on paragraph 19.
Yes, they were mandated to take legal action against the publishers of these hateful comments. The chairperson of the TCA, Mr. Erwin Pon, assembled a team of media-savvy members to identify the particulars of the authors of the most egregious anti-Chinese Facebook comments. Following what he described as the funnel approach, Mr. Pon's team eventually narrowed down the list to 12. They settled on 12 authors on whom Mr. Pon was conclusively satisfied had been positively traced. The TCA then instituted these equality proceedings against these 12 authors, seeking expeditious, effective relief as promised by the Act. Of the 12 respondents, the third respondent never received service of the complaint. The third respondent is Cynthia Jeanette Leroux. Two respondents opposed the complaint. We refer to them as the opposers. The fourth respondent, David Clive Horn, and the eighth respondent, Marietta van der Linde de Klerk. The fourth and eighth respondents, the opposers, are represented by Otto Krause. Four of the respondents defaulted to respond to the complaint. They didn't even file a notice of intention to oppose. That's the first, second, sixth, and seventh respondents. We call them the defaulters. And the remaining 5 confessed to the complaint and consented to the relief sought. We call them the confessors. The directions hearings in this matter collectively took 4 days, and the inquiry ran for a total of 13 days over the course of a year. Unfortunately, the proceedings in this matter have not been expeditious as the Act promised. Instead, the proceedings were marred and delayed throughout by obstructive conduct on the part of the 4th and 8th respondents, ably assisted by their representatives. This should not have occurred. We will deal with it in the question of costs when we address you in that regard. Now, in addressing you on the merits, Justice Makume, I intend, or the complainant intends, doing the following. First, we're going to touch on the legislative and procedural framework. We're going to make a number of submissions regarding the Equality Court proceedings, the purpose, the nature, and the application and interpretation of the Act. Second, we're going to highlight the substantive provisions of law in terms of which the relief against the respondents has been sought. In particular, the Section 10 hate speech provision, prohibiting hate speech, the Section 11 prohibition against harassment, and the Section 7 prohibition against unfair racial discrimination. Third, we're going to focus or emphasize the critical question of context in the present matter. Thereafter, I will be addressing you on the case against the 8th respondent, Marietta van der Linde de Klerk. Following upon that, my learned junior, Mr. Ben Winks, will be addressing you in relation to the case against the 4th respondent, David Clive Horn. And following upon that, my learned junior, Ms. Kathleen Hardy, will be addressing you in relation to the case against the confessors and defaulters. You might recall, Justice Makume, although it has been a while back, that Mr. Winks, myself, and Ms. Hardy have addressed you on each of those sets of respondents during the course of the inquiry and dealt with each of those respondents in the inquiry. Finally, I will pick up the baton again and deal with the question of costs and sum up in a conclusion. Thank you. Justice Makume, let's start out with the Equality Court proceedings. That commences really at paragraph 32 of our heads. We indicate and submit that there is a unique purpose and nature of Equality Court proceedings. Equality lies at the heart of our Constitution. It is a fundamental right in the Constitution. It is a guiding principle underpinning many of the other rights in the Constitution. It is dealt with in the preamble to the Constitution. The Act is the legislation required by Section 9 of the Constitution to prevent and prohibit unfair discrimination, and thereby to promote the achievement of equality. Thus, the Act, by focusing on equality, endeavors to facilitate a transition to a democratic society from the autocratic, racist one we stem from. The Act and its application are to be guided by the principles of equality, fairness, equity, social progress, justice, human dignity, and freedom. Those words don't just appear as fluff in the ether, Justice Makume. They are to be given real meaning, and I will demonstrate what that meaning is when it comes to the facts in this case. A key element of the Act is the provision of enforcement mechanisms, the central one being the equality courts. It's the institutional mechanism through which victims of inequality can obtain redress for wrongs committed against them. And the drafters of the Act did what they could to make equality courts as accessible as possible. They, for example, allowed a complainant to bring a claim unrepresented or even represented by a non-lawyer. They allowed the presiding officer and encouraged the presiding officer to play an interventionist role. They include broad standing provisions. They remove the ordinary monetary limit on the jurisdiction of magistrates. That's the purpose of the Act. the nature of the proceedings in an equality court hearing are governed primarily by the regulations to the Act. They explicitly create informal courts where substance is meant to triumph over technicality. The Equality Court is thus a specialized court. It has adopted expedited rules, a more informal procedure, and applies different evidential thresholds to that of the High Court. And the formal, adversarial, often expensive and potentially intimidating proceedings that prevail in an ordinary court and which may act as a barrier to those seeking justice have no place in an equality court. This is because the creation of a user-friendly court environment where proceedings are conducted along inquisitorial lines with an emphasis on informality, participation, and the speedy processing of matters is an integral part of the Act. This objective goes to the essence of what equality is because it emphasizes the need to make the judicial process available to all complainants. The law of evidence, accordingly, including the law relating to competency and compellability as applicable in civil proceedings, applies in respect of an inquiry, provided that fairness, the right to equality, and the interests of justice should, as far as possible, prevail over mere technicalities. Now, Justice Makume, I want to take you to a leading case in this regard. If you're able to turn to the authorities bundle, you will see the case flagged there. This is the complainant's authorities bundle. The flag should be item 5.
Yes.
And it appears at page 148 of the authorities bundle. It is the case of George and others versus Minister of Environmental Affairs and Tourism, 2005, volume 6, SA 297, Equality Court. The judge there presiding is NC Erasmus J. Do you have that before you, Justice Makume?
What, the case?
Yes.
No, I don't have the case before me. I'm
Okay.
just giving it.
Okay.
Okay. You may proceed. I've taken down the citation.
Certainly. I'm just going to highlight a few passages for you.
Yes.
I will then I will then refer you to those cases, to the references, I beg your pardon. In fact, I'm going to endeavor to share this screen with you.
Please do so. That will be of great help to me.
Right. Are you able to see my screen now, Justice Makume?
Yes, I can see that, yeah.
Wonderful, thank you very much. So this is the case of George and others. It's a 2005 decision. You'll see that the issue there was the respondents in an equality court objected to the complaint against them. They raised the defense of Liz alibi pendants. They said you suing the same party in a different court arising out of the same cause of action. And they raised this technical objection. The court had the following to say about equality courts. At paragraphs 6 and 7, it addressed this issue. At paragraph 7, and I'm reading from the highlighted section, it says, claims under the Equality Court must be brought before, under the Equality Act, must be brought before an equality court. It's not a new court, but it is a high court who is designated magistrates court, the presiding officers and judges and magistrates who've been specially equipped to meet the needs of the accessible and user-friendly adjudication of equality claims. Accessible, user-friendly adjudication of equality claims is what I emphasize. The parties in equality proceedings are not required to file formal pleadings. Proceedings are instituted and defended with a minimum of formality. paragraph 9, the highlighted sentence reads, are designated or designed, I beg your pardon, to be flexible and informal. Paragraph 10. Moreover, Section 29 of the Equality Act imposes a positive duty on the state as far as reasonably possible to assist any person wishing to institute proceedings in terms of or under this Act. This means not only that the administrative functionaries of the Equality Court are obligated to assist the applicants, but also that the respondent is obliged to do so. He or she is not permitted to act in an obstructive way. The Act makes it clear that it is not open to the state to conduct itself in proceedings under the Equality Act as it might do in the ordinary adversarial litigation. Instead, its conduct should be directed at the achievement of justice and not a victory at any cost. Let me pause there, Justice Makume. We would respectfully submit that that sentiment applies not only to the state, but to any respondent under the Equality Act, where they are faced with proceedings in the Equality Court. He or she is not permitted to act in an obstructive way. They should not conduct themselves as they would do in ordinary adversarial litigation. Their energies should not be directed at the achievement of a victory at any cost. That applies with equal relevance to the 4th and 8th respondents. The court then dealt with guiding principles, in particular at paragraph, the fundamental principles guiding proceedings which are instituted under or in terms of the Act appear to be directed primarily at facilitating ease of access to justice for the victims of unfair discrimination and inequality. That would mean all the Chinese South Africans represented by the TCA who are subject to the unfair discrimination and the hate speech and the harassment alleged to occur on the part of the respondents. 12. An integral part of the Act is the focus on the creation of a user-friendly court environment where proceedings are conducted along inquisitorial lines with an emphasis on informality and participation and the speedy processing of matters. The formal, adversarial, often expensive and potentially intimidating proceedings that prevail in an ordinary magistrate's court or high court and which may act as a barrier to those seeking justice have no place in an equality court. Now I pause here, Justice Makume. The court will be well alive to the technical, adversarial, expense-inducing, incredibly intimidating process that the 4th and 8th respondents, ably assisted by their legal representatives, embarked upon and subjected the TCA and its representatives to in the course of these proceedings. In short, they undermined these proceedings and the purpose of these proceedings under the Act. The court then went further and highlighted the essence of the complaint. At paragraph 18, it stated, the respondent opposes the hearing of the matter by the Equality Court and argues that it should be referred to the High Court for hearing. That was, of course, Justice Makume, in accordance with the Liz Alibi technical defense. And this is what the court had to say, or describing the respondent's case. I'm reading at paragraph 28. In the event, however, of the matter proceeding in this court, respondent raises a preliminary objection of Liz Pendens, arguing that it is prima facie vexatious to bring two actions in respect to the same subject matter at 29, Ultimately, respondent argues that the following considerations of fairness and convenience dictate that the application in this court should be stayed and the application in the High Court should continue. So what the respondent was doing there, Justice Makume, was claiming artificially the high moral ground. The respondent was essentially saying, my rights are being threatened and infringed, and I want to raise all sorts of technical objections in order to vindicate my rights. Those technical objections accord with an adversarial process. Those technical objections ride roughshod over the informal process and purpose of the Equality Court. The court per Erasmus J was having none of that. The court concluded at paragraph 30 that the move away from formality and procedural technicalities, the fact that the Equality Court is intended to be a more informal, proactive court, does not mean that it is less competent to deal with challenging issues. Invariably, difficult and controversial cases will come before the Equality Courts, and complainants should not be denied access in such cases. This decision was confirmed on appeal before the Supreme Court of Appeal. Cameron J.A., as he then was writing for a unanimous court in the SCA. And that reference is 2007, Volume 3, South African Law Reports, page 62. The reason I have taken you to that document, Justice Makume, is precisely to demonstrate that the courts have pronounced very emphatically and repeatedly on the nature and purpose of Equality Court proceedings. And if you bear with me a moment, and that nature and purpose has been subverted entirely in this matter here. If I could focus on the application and interpretation of the Act whilst describing the Equality Court proceedings.
Sorry, was this done in the Cameron judgment?
I beg your pardon, Justice Makume?
Was this there in the Cameron judgment?
No, I'm saying the decision was upheld on appeal in the Cameron judgment.
Yeah, that is what I'm referring to. Yeah, okay.
That's correct. But the Cameron judgment didn't directly address in as great detail the enunciation by Erasmus J. In the High Court, but it upheld the entire decision.
Okay.
Insofar as application and interpretation of the Act is concerned, we point out that the court must apply the Act and interpret its provisions to give effect to the Constitution, as well as the preamble, objects, and guiding principles of the Act. And as will be demonstrated shortly, the interpretation and application of the Act must emphasize in particular context. Similarly, Section 4.2 of the Act requires that the court take into account the existence of systemic discrimination and inequalities in all spheres of life as a result of past and present unfair discrimination brought about by colonialism, apartheid, and patriarchy, and the need to take measures to eliminate such discrimination and inequalities. And when interpreting the Act, regard should be had to the salutary words of Muhammad DP, as he then was, in the Shabalala decision of the Constitutional Court. And he said, the past was pervaded by inequality, authoritarianism, and repression. The aspiration of the future is based on what is, quote, justifiable in an open and democratic society based on freedom and equality, unquote. It is premised on a legal culture of accountability and transparency. And that is the premise on which the Equality Act works, Justice Makume. I would now deal with the substantive provisions that we rely upon. The first substantive provision that the complainant relies upon is the Section 10 prohibition against hate speech. As you are aware, that provision was reworded by the Constitutional Court decision in Kwelane recently. And it provides that no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred. Now, the prohibited grounds are defined in Section 1(1) of the Act to include race and ethnic origin or any other ground where discrimination based on that other ground causes or perpetuates systemic disadvantage or undermines human dignity. Hate speech is not a crime, it's a civil or statutory delict, it's a civil wrong. Each element must be proved objectively, rather, on a balance of probabilities. And in relation to each respondent in this case, this court must be satisfied on a balance of probabilities of three things. First, that the impugned words were indeed published by that particular respondent. Secondly, that the impugned words were based on race or ethnic origin, that is referring to Chinese people. And third, that the impugned words could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm, and a clear intention to promote or propagate hatred. This notion of inciting harm is not limited to physical harm. In the Concord decision in Kwelane, it was pointed out that it could be emotional or psychological harm as well. In the Kumalo decision per Sutherland, J, it was pointed out that harm may manifest in three ways. First, people outside the target group may be encouraged by the hate speech to also shun, denigrate, and abuse the target group. In other words, the respondents' comments could encourage third parties, non-Chinese persons, to also shun, denigrate, and abuse Chinese South Africans. Second, people inside the target group, namely Chinese persons in South Africa, could be severely negatively impacted. Their sense of self-worth and acceptance could be undermined. And they may in turn be caused to take drastic measures in reaction. And the third form of harm that was foreshadowed in Sutherland's decision is the harm to the social cohesion in South African society, which undermines the nation-building project. This notion of the intention to promote or propagate hatred is also unpacked, Justice Makume, under the prohibition of hate speech. And in Kwelane, the Concord held that hatred denotes detestation and vilification on grounds of group identity. So we detest and vilify the Chinese in South Africa. Now, I'd like to again refer you to the decision in Kwelane, the recent Constitutional Court decision. Are you still able to see my screen?
Yes, I'm able to see it.
Okay. You'll see that it's the 2021 volume 6579 CC law report. It was a unanimous decision by the Constitutional Court per Majid J. There are a number of eminent counsel presenting, including Gilbert Marcus, Andrea Gabriel, Kate Hofmeyer, Wim Tringove, Tembegangu Kaitobi. There were a slew of superb counsel making submissions that ultimately culminated in the judge's decision. In short, that case involved a newspaper article written by Mr. Kwelani, published in 2008, in which he likened homosexual conduct to bestiality. The South African Human Rights Commission referred a hate speech complaint to the Equality Court. Mr. Kwelani responded by instituting a High Court application challenging the constitutionality of Section 10. Section 10 is the hate speech prohibition. Now, this is what the court had to say. Firstly, at paragraph 95, it stated that hate speech is a statutory delict and not a crime. I've already covered that in my submission. I just want to identify the relevant passage in the judgment. Secondly, it pointed out at paragraph 96 that the test for determining hate speech when one looks at the impugned words is an objective, reasonable person test. To quote, the phrase that could reasonably be construed to demonstrate a clear intention, unquote, postulates a subjective, whether the phrase postulates a subjective objective test, in my view, it is plainly an objective standard that requires a reasonable person test. Thirdly, as submitted already, the notion of hatred is predicated on vilification and detestation on grounds of group identity. That appears at paragraphs 181 and 182. Paragraph 155, harm is understood as emotional and psychological harm in addition to physical harm. And those essentially are the main contours of that decision that has a bearing on this case. So that deals with the prohibition on hate speech under Section 10. The second substantive provision that we have regard to in the case against the respondents is Section 11, Justice Makume. That is the prohibition against harassment. Harassment is defined by the Act as meaning unwanted conduct, which is serious and demeans, humiliates, or creates a hostile or intimidating environment, and which is related to a person's membership or presumed membership of a group identified by one or more of the prohibited grounds or a characteristic associated with such group. In other words, it's unwanted conduct, which is serious, and it humiliates or creates a hostile or intimidating environment for Chinese persons in South Africa. Harassment is similarly a statutory delict, not a crime. And again, the decision in Kwelani by the Concord indicates that it must be established objectively on a balance of probabilities. We will demonstrate that the hate speech prohibition and the prohibition against harassment have been contravened by all the respondents. The third substantive provision that we say the respondents have contravened is Section 7 of the Act, dealing with unfair racial discrimination. Not mere unfair discrimination, but unfair racial discrimination. 7A provides that no person may unfairly discriminate against any person on the ground of race, including the dissemination of any propaganda or idea which propounds the racial superiority or inferiority of any person, including incitement to or participation in any form of racial violence. Again, it's a statutory delict, not a crime. And we submit that each of the respondents in this matter has disseminated ideas which propound the racial inferiority of Chinese people and contravenes Section 7A as being unfair racial discrimination. We will demonstrate that in turn. A final word on the Act before I deal with it. And I'd like to talk about context. The Act focuses in particular on context. It places strong emphasis on the need for the Equality Court to look at context in order to understand the meaning and implication of the impugned words in each instance. Firstly, Section 4.2a of the Act provides a guiding principle. It reads as follows, and I've pulled it up on the screen as well, if you can see that. Section 4.2a provides that in the application of this Act, the following should be recognized and taken into account. A, the existence of systemic discrimination and inequalities, particularly in respect of race, gender, and disability in all spheres of life, as a result of past and present unfair discrimination brought about by colonialism, the apartheid system, and patriarchy. A second provision of the Act which causes us and the court to place due emphasis on context is Section 3.3 of the Act, which deals with interpretation. You'll see Section 3 is headed Interpretation of the Act, and subsection 3 provides as follows. Any person applying or interpreting this Act must take into account the context of the dispute and the purpose of the Act. A third contextual marker is Section 14 of the Act, where the question of the fairness or unfairness of discrimination is being considered. There, Section 14.2 provides in determining whether the respondent has proved that the discrimination is fair, the following must be taken into account. A, the context. Section 14.3 provides that the factors in subsection 2b include the following. These are factors also that need to be taken into account. And 3c provides the position of the complainant in society and whether he or she suffers from patterns of disadvantage or belongs to a group that suffers from such patterns of disadvantage. The point that I am laboring here, Justice Makume, is that the Act places considerable emphasis on context to determine whether impugned words in their context constitute any of the prohibitions against hate speech or unfair discrimination, racial discrimination, or harassment, as viewed against the complainant's position in society. In Kwelani, the Constitutional Court also noted the importance of context in applying the Act. It referred to its previous decision in Rustenburg Platinum Mine, where the words swart man, black man, were referred to. And in that context, those words were considered to be racist and derogatory. This is what the court in Kwelani had to say. Rustenburg Platinum Mine, that is its decision in that regard, or decision in that case, demonstrates how the effect of even facially innocuous words must be understood based on the different structural positions occupied by white people in relation to black people in contemporary South African society. This approach takes cognizance of how words, or more broadly, expression, contribute towards creating or exacerbating systemic disadvantage and subordination. Justice Makume, it's not a leap in faith or logic to substitute the black people for Chinese people in that context, in this particular case. the structural positions occupied by white people as the respondents in relation to Chinese people, who are the complainants in contemporary society. And the words complained of must be understood in that context, even apparently innocuous words. In this case, we submit the words were far from innocuous. In short, we submit that when assessing the words used by the respondents, the court must bear in mind our country's ugly history of white supremacy, including towards Chinese people, and the need to take full cognizance of how Chinese people in South Africa have been marginalized in the past and continue to be marginalized in the present. In that regard, the complainant presented uncontroverted evidence in relation to two broad groups of persons of Chinese race or ethnic origin living in South Africa. The first was the South African-born Chinese who have short or long ancestral lines in South Africa, the long lines running to 4 or 5 generations, and migrant Chinese South Africans who have who were born abroad and live here presently. The affidavits of Melanie Yap set out, the affidavit of Miss Melanie Yap sets out the history of the South African-born Chinese people from the time that a Chinese person first arrived in the Cape Colony in the 1600s until the fall of the apartheid government in the 1990s. That's a period of about 400 years they've been present in this country. The affidavit of Mr. Henry Wing gave personal evidence of the experience of being a Chinese-born South African from 1945 to the present. The affidavit of Mr. Yap and Miss Yap and Mr. Wing was not challenged. And Mr. Pon, Mr. Erwin Pon, on behalf of the TCA, as the chairman of the TCA, also explained in his testimony that he was a 4th-generation Chinese person living in South Africa. I'm not going to traipse through that evidence in any great detail. It is before the court in the form of its affidavit, in the form of those affidavits. I would like to highlight the following. In relation to the South African-born Chinese, the contextual marker demonstrates that the uncontested evidence shows that from colonial times, the Chinese people were persecuted. In particular, during colonial times, the white settlers and various colonial governments went to great lengths to persecute Chinese persons. In the late 1800s, Chinese men were brought in as indentured laborers. Local white settlers referred to them as thieves and coolies. They were traded as Chinese labor, and it was referred to as the piglet trade, referencing the pigtails worn by some Chinese at the time. Colonial officials recorded Chinese names incorrectly, which meant many people lost their names. And all South Africans of color can empathize with this, Justice Makume. How many Black South Africans have had their names bastardized through the apartheid system? How many South Africans of Indian descent have similarly suffered that difficulty? Chinese people arriving in South Africa were not allowed to reside in Natal. They were confined to compounds. The Cape Colony passed legislation preventing them from entering or even residing in the colony. The Free State government simply banned Chinese people altogether. The Transvaal government confined them to labor compounds and introduced flogging and torture. The Union and apartheid government also discriminated against the Chinese in pernicious ways. They were excluded from schools and universities, white schools and universities. They suffered extended discrimination at the hands of the apartheid state. They were classified as colored, not being able to vote, not being able to marry white people, subjected to the vagaries of the Separate Amenities Act, denied access to healthcare and education. They suffered under the Group Areas Act. It created the unique insecurity and hardship for them. They also suffered under expropriation, relocation, and forced removal. Mr. Wing in particular explained his painful experience, how his family was forced to move out of their residence in Fitas during the 1970s. And all the while, white South Africans treated South African-born Chinese as inferior. you had considerable evidence before you, Justice Makume, where witnesses told of being bullied by white children at school, of being forced to eat chalk, of being called names such as Ching Chong Chinaman, of being physically assaulted, of being routinely taunted when traveling on public transport and being insulted with various pejoratives, of being undignifiedly forced to stand in shop queues until all the white people had been served first. Mr. Wing also explained how his parents' shop was raided by white government officials when he was a child, and how he was forced to be fingerprinted by government officials as an 8-year-old. Now, this is the experience of Chinese South Africans who see these words, Justice Makume, of the respondents, these hateful words by the respondents. And it is viewed in this context, or one must view this context to determine whether those words constituted hate speech, unfair discrimination, and unfair racial discrimination and harassment. It is this relevant context. Similarly, in relation to migrant Chinese, the uncontested evidence demonstrates that they suffer social marginalization and vulnerability. They have limited education. They start up with limited capital. They have limited English proficiency. They operated in the lower socioeconomic rungs of society. South African government officials, as well as criminals, appear to hold stereotypes about Chinese people, including that they hold cash, which leads them often to becoming victims of extortion and other crime. Professor Yoon Park, who was the expert and perceived as Chinese, even though she isn't, gave testimony of her personal experience of being racially profiled by a traffic officer, routinely harassed and racially profiled by border officials. The uncontested evidence is that the migrant Chinese experience is one of social isolation and loneliness. They are generally poor, with poor formal education and language skills. They find themselves working in small towns for long hours, living in back rooms of their shops to save money. They struggle to integrate with local communities. They have difficulty accessing healthcare or attending local churches. Again, that is a contextual marker against which this court must evaluate the impugned words complained of to determine whether they are harmful, to determine whether they promote hatred, to determine whether they constitute harassment, and to determine whether they amount to unfair racial discrimination. And that context is undisputed. Justice Makume, I'd now like to deal with the case against Marietta van der Linde de Klerk. What has happened is I've thus far described an introduction to this case. I've dealt with the procedural framework of equality court proceedings. I have highlighted the substantive legal provisions, section 10, 11, and 7, under which this case has been brought. I have focused on the important question of context against which the impugned words have to be interpreted in each of the respondents' case. I have illustrated to you what the context is regarding the experience of South African-born Chinese and migrant Chinese, which is undisputed. I'm now dealing with the case against the 8th respondent. Now, the 8th respondent is alleged to have committed hate speech, harassment, and unfair racial discrimination against Chinese people. She's alleged to have published the following words on Facebook: "We need to get rid of Chinese in SA. They not welcome. They steal our economy. Dogs, rhinos, and now donkeys. I think the same as the donkeys can be applied to dogs and our pets." Now, the 8th respondent's stance is that she denies publishing the words and puts the complainant to the proof. Essentially, Justice Makume, there are 3 issues that the complainant has to come home on in order to demonstrate to you that we are entitled to relief against the 8th respondent in terms of the provisions of the Act. Those three issues are as follows. First, were the impugned words, which I've just read to you, published on the Carte Blanche Facebook page on 31st January 2017 by a user with the username Marietta V.D. Linda de Klerk? If you excuse me a moment.
Yeah.
The second leg we have to come home on, Justice Makume, is we have to demonstrate that there is a link between that username, Marietta V.D. Linda de Klerk, and the 8th respondent, Marietta van der Linde de Klerk. In other words, we have to demonstrate to the court that the person using that username who published those words is in fact the 8th respondent. And thirdly, we have to demonstrate to you, Justice Makume, that the words objectively viewed in accordance with a reasonable person test and having regard to the context I described above, constitute hate speech, harassment, or unfair discrimination. We've got to come home on all three of those elements in order to succeed in our relief against the 8th respondent. The threshold for determining all of that is on a balance of probabilities, Justice Makume. I'm going to deal with each of those points in turn. The first issue that we have to persuade the court on is that the impugned message was published at the relevant time on the Carte Blanche Facebook webpage by a person using the username Marietta V.D. Linda de Klerk. We submit, Justice Makume, that on a conspectus of the evidence before you, it is absolutely plain that that is what happened, i.e., it is a fact that the impugned comment was published on the Carte Blanche Facebook webpage on 31st January 2017 by a person with that username. Why do we say that, Justice Makume? Well, for a number of reasons. The first reason is that we have a screenshot evidencing the fact that the comment was published on the Carte Blanche Facebook webpage. The original comment published by that person on the Carte Blanche Facebook webpage was deleted, Justice Makume. It was deleted by Carte Blanche, although you will see that in earlier correspondence, the 8th respondent indicates that she deleted it. But the bottom line is it was deleted. Therefore, the only contemporaneous piece of evidence demonstrating that the comment appeared on the Carte Blanche Facebook webpage was a screenshot. Ms. Sadler has dealt with the question of screenshots. She pointed out And this is at page 289 and 290 of the transcripts bundle. I'm using the pagination that appears in the top right-hand corner. She pointed out that a screenshot is how you visually capture exactly what is on a screen at any given point. Whether it's a cell phone or a computer screen, you press a series of buttons, which causes the device to take an actual digital image using the operating system on that device. It looks like a photograph, but you don't create it using a camera. You do not take a camera and take a picture. You generate a digital capture of what appears on the screen by the particular device. Why does she?
Just before you proceed on that aspect, you'll recall that the objection to that evidence was to the fact that the screenshot was taken by a certain Liz, and therefore it is hearsay. Will you be positioned to deal with that later?
I will deal with that.
We dealt with that at some point in the interlocutory to some extent, but that was the main objection, that she did not take it herself, but it was by Liz, who did not give evidence.
Thank you, Justice Makume. We deal with that in the very next point. So I just want to deal with the screenshot first, Justice Makume, and then we'll deal with the corroborating evidence that overcomes any hearsay objection.
Okay.
So Ms. Sadler says she uses a screenshot. It's not a photograph. So the complaint in Mr. Garvey's heads of argument that there's a confusion between screenshot and photograph is unfounded. Ms. Sadler's evidence is very plain as to what a screenshot is. She also informs the court why she uses screenshots. She says it's something she relies on every day to create evidence. She creates a paper trail in court cases, particularly where the first part of the strategy is to get rid of the content, to get it deleted. And she says, and so we take a screenshot to preserve the evidence to be used in litigation if it disappears. Now, in exactly this case here, Justice Makume, in the same situation, we're in the same situation in this case, I beg your pardon. The original comment had been deleted on the Carte Blanche Facebook page. And now Ms. Sadler had used a screenshot in order to preserve it. And we know that it was deleted because Ms. Sadler's evidence was to that effect. She tells us at page 309 that the Carte Blanche and Donkey Sanctuary entities acted very quickly and deleted the offending comments.
So in other words, she took the screenshot and thereafter they deleted.
That is correct.
After the screenshot had been finished to her. Okay.
That is exactly right, Justice Makume.
A screenshot would be like a photocopy. Let me put it that way. Something like photocopying it. It's exactly the same.
Exactly right. Even more accurate, but exactly analogous to that. Okay. Justice Makume, she tells us what the screenshot is. If you want a reference to that, it appears at page 291 and 292 of the trial bundle.
The 291.
291 and 292.
Yeah, okay. Yes, fortunately I've got it on my other screen here. Yeah, okay.
Okay. And she indicates that she uses it to preserve evidence in exactly the way that you describe. She points out that Carte Blanche deleted the original comments, and that much is plain also from Mr. Pond's evidence. It's nothing controversial in that regard. That is why the complainant is relying on the screenshot to demonstrate this first proposition, that the comment was made on the Carte Blanche Facebook webpage at the time by a person with that username. Now, The concern that the screenshot might arguably constitute hearsay evidence is, with respect, a red herring. It falls away. And it falls away because we have the corroborating evidence of Ms. Emma Sadler. Remember the proposition we're establishing here, Justice Makume?
Yes.
We're establishing the proposition that that impugned comment was made on 31st January 2017 on the Carte Blanche Facebook webpage by a person using the username Marietta Vidilende de Klerk.
Sorry, just hold on, let me just switch off. Sorry, sorry about that. Okay.
No worries. Thank you, Justice Makume. And we're saying the second piece of evidence that demonstrates this fact and removes any question of hearsay is the corroborating evidence of Emma Sadler. And what do I mean by that? Well, she personally viewed the comment, the 8th respondent's comment, on the Carte Blanche Facebook webpage at the time. She personally evaluated that comment. She personally chose that comment as part of this litigation. She personally transcribed that comment from the screenshot which she asked Lizzie Harrison to thereafter make. And importantly, Justice Makume, she recalls doing all of this. Now, where do I find that? If you look at the transcript bundle,
Yes.
you will see at page 302, again, I'm using the pagination on the top right corner.
302.
302.
Okay.
You'll
Yes.
see that Ms. Sadler is being led by myself. Are you at page 302 yet?
Yes, I'm there. I'm there.
Okay.
Page 302.
Thank you. Thank you, Justice Makume. You'll see I say to her, Mr. Ismail, Ms. Sadler, this is the complaint form issued by the TCA in about May 2017. So I've referred her to the complaint form. Under Part E on page 19, the header reads, particulars of complaint and relief sought. Should be relief. Page 19, as you can see, describes a number of comments and attributes each comment to the respective respondent. And then we deal with the 4th respondent's comment. And at line 20, I continue. I say to her, the 8th respondent's comment further down makes the allegation that on or about 31 January 2017 at about 6:06 p.m., the 8th respondent posted a comment on the Facebook page of the television show Carte Blanche, inter alia, stating her view in respect of the Chinese people, being that, quote, we need to get rid of Chinese in SA, they're not welcome, they steal our economy, dogs, rhinos, and now donkeys. I think the same as the donkeys can be applied to our dogs and pets, to dogs and our pets. I say to her, now you indicated to the judge that you looked at the Facebook pages and there were literally hundreds of offensive comments. Do you recall the specific comments being included in your takedown notices? The specific comments, Justice Makume, I'm referring to the 4th and the 8th. This is what she says in response. Ms. Sadler, I remember including one of these comments in the takedown notice, and I think one or both of them in the press release, which I drafted for the Chinese Association, which was a couple of days after. I say we will come to the press release immediately. She continues, but certainly I remember reading these comments myself on the original platform. Justice Makume, she's telling the court that she saw those comments on the Carte Blanche Facebook webpage, or at least the 8th respondent's comment. I'm dealing with the 8th respondent now. I also remember using screenshots, which were obtained by my associate at the time, Lizzie Harrison, of these specific comments which she sent to me. So not only did she see those comments, she directed Lizzie Harrison, her then associate, to take screenshots and send to her. And I read on, and I transcribed for the purposes of including them in the letter and the press release. I transcribed them myself. And I asked her, Ms. Sadler, why would you recall these two particular comments out of the hundreds that you came across? She says, as I say, there were really hundreds. Modus operandi in going through the content was to include the most, what I thought, using my experience and subjectivity, were the most egregious and the most hurtful. It wouldn't have been practical to include every single one of the comments. So my modus operandi in going through that content was to highlight, to capture, to obtain, and to include the most serious of the comments that I came across. Now, coming back to our submission, Justice Makume, the first proposition we had to demonstrate was that the impugned message was published at the relevant time on the carte blanche Facebook webpage by a username, Marietta V.D. Linda de Klerk. I've indicated that the first piece of evidence demonstrating that was the screenshot. I've now pointed out to you that that was corroborated by Ms. Sadler, because she viewed this very comment on the web page itself. She also transcribed the comment from the screenshot that was taken contemporaneously by her associate at the time, Lizzie Harrison. And she recalls doing all of this. Whatever complaint you therefore hear from the 8th respondent regarding hearsay is disposed of. To the extent one can argue that the screenshot was hearsay, quite frankly, Justice Makume, we don't even have to get into that argument, because it has been corroborated by the direct personal testimony of Ms. Sadler, who saw it online and recalls it. But things get even worse for the 8th respondent, Justice Makume, on this first point, namely that the impugned message was published on the carte blanche Facebook webpage by a user using the username Marietta V.D. Linda de Klerk. And I say that for the following reason. The 8th respondent was provided with the original phone with which the screenshot was taken and on which it was stored. The 8th respondent hasn't quibbled with the fact that the phone was used to take the screenshot or that it was stored on the phone. If you bear with me a moment. You'll see from the transcript at page 1672, 1672.
Okay, let me get there. 1672.
That's correct.
Yes, I'm there.
Mr. Garvey, on behalf of the 4th and 8th respondents, he clears up this question of the phone. He says, my lord, maybe I will be of assistance. I can clear this up. Insofar as somebody was sent to have a look at the phones of Ms. Sadler, 100%, let us accept somebody did do that. Now, I can take you through the repeated references in the transcript where we tendered the phone. We said, that's the phone that was used to take the screenshot. That was the phone on which the screenshot and the WhatsApp message conveying that screenshot to Ms. Sadler is stored. They had possession, control of, and inspection of the phone, they being the 8th respondent. They have not disputed the content or authenticity of the screenshot taken by Ms. Sadler. They have not, with reference to a shred of cogent evidence, demonstrated that the screenshot was a fabrication, nor can they, because there is no such evidence demonstrating that. And all the evidence demonstrates the contrary, namely there was an integrity in the chain moving from Ms. Sadler viewing it on the web page all the way to the production of a printout before the court. Justice Makume, you can only contrast the position of the 8th respondent regarding the screenshot against the position of the other respondents before you. And when you do that exercise of contrasting the position of the respondents, it becomes a further factor to take into account to establish the veracity of the screenshot and the assertion or the fact that the impugned comment was made, and the defense by Ms. Mariette van der Linde de Klerk is without substance. And what I mean is as follows. All the respondents, the confessors certainly, they admit that Ms. Sadler's screenshot, or they don't dispute that Ms. Sadler's screenshots constitute evidence of the relevant comment they made and which is attributable to them. They don't dispute that. They accept it. Even the 4th respondent, who Mr. Garvey is representing, himself relies on a screenshot as evidence that his comment was made. In that regard, I refer you to the transcript at page 775.
Page 775.
That's correct, Justice Makume. 775.
Are you sure it's 775? It's Mr. Pond. Okay.
The pagination is on the top right-hand corner. That's the pagination I'm employing, Justice Makume.
Yes.
775. Mr. Winks is speaking here. He's referring to a document. And he says, if I may just explain this document, he's leading Mr. Pond's evidence. And he says, if I may just explain this document, this was adduced by the court's respondent's representative, Mr. Hitchcock, during March. I think he means the 4th. The transcriber means the 4th respondent's representative, Mr. Hitchcock, during March. Mr. Hitchcock was the 4th respondent's representative. He entered this into evidence. He indicated that this is a screenshot that had been taken by the 4th respondent of the comment that he introduced. Now, Justice Makume, that demonstrates that even the 4th respondent is relying on a screenshot as evidence of his comment being made. To sum up on this first point, Justice Makume, we say that the evidence is uncontroverted that an impugned or the impugned message was published at the relevant time on 31st Jan 2017 on the Carte Blanche Facebook webpage by a person with the username Mariette V.D. Linde de Klerk. We say that because we have a screenshot demonstrating as much, and I've given you the context and meaning of the screenshot and why it was used and how it was used. And to the extent that the 8th respondent wants to quibble by introducing the technical defense of hearsay, quite frankly, that is an entire red herring and an irrelevancy, because we have the corroborating evidence of Ms. Sadler, who viewed it online on the Carte Blanche Facebook webpage, who then evaluated the comment and decided to use that comment for purposes of the TCA's litigation, she transcribed the comment personally from the screenshot that she asked her associate to take of the comment, and she recalls doing all of that. There can therefore be no dispute regarding the first proposition. It's reinforced by the fact that none of the other respondents quibble with the screenshot. It's reinforced by the respondent who is represented by Mr. Garvey himself relies on a screenshot as evidence that the comment was made. And finally, the eighth respondent cannot suggest that it is a fabrication or that the screenshot was doctored, nor has she. There's not a shred of evidence to indicate as much or to dispute Ms. Sadler's corroborating independent evidence. I come now to the second submission I said we need to demonstrate in order to come home on a claim against the eighth respondent. And this is the linking submission, Justice Makume. And on the submission, we demonstrate or we submit to you that on a conspectus of all the evidence, it is clear, let alone on a balance of probabilities, it is absolutely clear that there is a link between that username, Marietta Vidi Linda de Klerk, the person who published the impugned comment, and the eighth respondent, Marietta van der Linde de Klerk. Now, why do we say that? For several reasons, Justice Makume. We say that for several reasons. The first reason, the first reason is that she admits as much through her own lawyer's correspondence. She tells us that. And we have dealt with this in our heads of argument at paragraph 173 onward, or page 69 of our heads. 4 separate letters under her previous attorney's name, Nolte Incorporated. She conveys clear admissions that she had indeed published the comment. In other words, the eighth respondent, Marietta van der Linde de Klerk, tells us through her lawyer's letter that, yes, I have published that impugned comment and that's my username. We have set out for your benefit with reference to the underlying letters where she has made those admissions. It is abundantly plain from those admissions that she is in fact the author of the impugned comment and the actual person behind the online username. The second point we wish to make in that regard, Justice Makume, is that in the course of cross-examination, the eighth respondent's version that was put to the complainant is that the eighth respondent is indeed a Facebook user, and indeed she posts on Facebook as a Facebook user. In that regard, I'll refer you to the transcript. And this version is put twice by Mr. Garvey on behalf of the eighth respondent. The first time, it appears at page 573 of the transcript bundle.
573, okay. Yes. That's
correct. At the top of the page, Ms. Sadler says, so if you look at an activity log, I think it tells you if somebody liked something, if somebody liked something. So what they did on Facebook during a logged in session. So I believe it says that, say, for example, you could look at one of my logins and you would see that I liked this article. I commented on that person's post. I said happy birthday to that person. It tells you what you did on Facebook in a time period, I think. So she's giving her view on what the activity log does. It tells a person about what the Facebook user has done. The court says, like an audit. Ms. Sadler says, I think so. As I say, I'm not an expert on activity logs. It's not something I've used, certainly not professionally. Now, the transcript reads Mr. Barense, but as will become plain, it's not Mr. Barense. Mr. Garvey conceded that was an error. It is Mr. Garvey. It should read Mr. Garvey. And this is what he says. Mr. Garvey says the following. So if the 8th respondent is necessitated to do so, this obviously will assess the strength of the complainant's case. At the close of their case, it should be the 8th respondent being necessitated to incur further costs in this matter and bring an expert to this court that would say that he considered, or he, well, let us just say considered, for the lack of a better word, he considered the 8th respondent's activity log and the post that is alleged nowhere appears in that audit. What would your response be then as to the probative value of these screenshots? So what Mr. Garvey is saying to her, Justice Makume, he's saying, if we were to bring Miss Marietta van der Linde, the clerk's activity log for Facebook here, the version I'm putting to you, Ms. Sadler, is that her activity log on Facebook will demonstrate that she doesn't have this impugned comment. The court asks, sorry, what doesn't appear? Mr. Garvey says the post alleged. The court says the alleged post. Mr. Garvey says, Mr. Garvey says post. It will be showing on the 8th respondent, to be shown on the 8th respondent's Facebook account that no such post was made on her, the comments. So in other words, what he's saying is the activity log for Facebook, for the 8th respondent, will show that there is no such impugned comment made on a log. Ms. Sadler says, as I said, I don't know about activity logs. I don't know if you can go into an activity log from 2.5 years ago. I've only seen an activity log of what I've done in that particular session on that day. Mr. Garvey, so you will not be able to dispute that. Ms. Sadler, no. Now let me pause there. What he has effectively done is put the 8th respondent's version to the complainant's witness. That version is 1, the 8th respondent is a Facebook user. 2, the 8th respondent does have or does make posts on Facebook. 3, this is recorded by her activity log. That's what he's put. That's the version he's put. The second time he puts that version, Justice Makume, if you bear with me a second, it appears at page 578. It's further down on the page.
Yes.
He says, and the advocacy of hatred that was based on race, ethnicity, gender, or religion? He asks that question, Mr. Garvey does. Ms. Sadler replies, I believe there was an advocacy of hatred, I beg your pardon. Mr. Garvey says, and that in respect of the 8th respondent's alleged post? Ms. Sadler, yes, I believe so. Mr. Garvey continues, and notwithstanding the fact that if necessary, an expert will provide evidence that this post does not appear on the activity log of the 8th respondent. Again, he's putting to her the version that the 8th respondent is a Facebook user, the 8th respondent posts on Facebook, and the 8th respondent, he alleges, didn't make the comment. Now to come back to our heads, Justice Makume, I'm demonstrating to you that the evidence is clear that there's a link between the username and the 8th respondent. They are one and the same persons. I've pointed out to you that the 8th respondent has herself admitted that in correspondence on no fewer than 4 occasions. I've pointed out to you furthermore that her version is that she does post on Facebook. She's a Facebook user, and she does post on Facebook. There's a third string to our bow which demonstrates this evidence, or which demonstrates this fact. And that is the conduct of the 8th respondent in issuing a bold denial and putting the complainant to the proof. We deal with that at paragraph 169 onward. We point out that it's a bare denial. She refuses to take the court into her confidence regarding matters that are uniquely within her knowledge. She instead is content to snipe from the sidelines and try and poke holes in the complainant's case, which it merely has to establish on a balance of probabilities. The fact that she refuses to get into the witness box and subject herself to cross-examination on an issue which is uniquely within her knowledge can and does give rise, we submit, to an inference against her. It is yet a further factor that the court should, we respectfully submit, take into account to demonstrate the fact that there is a link in that the 8th respondent is using and did publish under the username Mariette van der Linde de Klerk, the impugned comment. It's a further factor. She does not tell the court whether she has ever had a Facebook account. She doesn't want to give evidence in that regard. She doesn't tell the court, she doesn't want to give evidence whether she bore the internet address or her Facebook account bore that internet address. She doesn't want to tell the court anything about herself other than putting you to the proof. Did she publish on some other comment on the carte blanche Facebook webpage? Do you have any explanation for the admissions made on your behalf by Nolte Inc. on no fewer than 4 occasions? Why have you dealt with the complaint in such an obstructive and aggressive manner? She refuses to elect to testify, even though she was present in court. In that regard, I want to refer the court to the decision of Gallant and Dixon. We've got it in our authorities bundle as item 4. It's an appellate division decision going back to 1950, volume 2, page 460. You'll see the bench comprised 3 judges, Schreiner J.A., the greatest Chief Justice that never was, Van den Heever J.A., and Murray A.J.A. And the court at page 146 of our paginated bundle says the following. In the case of the party himself who is available, as was the defendant here, it seems to me that the inference is at least obvious and strong that the parties and his legal advisors are satisfied that although he was obviously able to give very material evidence as to the cause of the accident, he could not benefit and might well, because of the facts known to himself, damage his case by giving evidence and subjecting himself to cross-examination. That's precisely the position that obtains in the present case with the 8th respondent. If she got into the witness box and exposed herself to cross-examination, the only reasonable and plausible inference is that she would give evidence in relation to these material facts uniquely within her knowledge, and her failure to do so gives rise to the inference that she would expose herself to cross-examination and damage her case thereby. The court says it's not advisable to seek to lay down any general rule as to the effect that may properly be given to the failure of a party to give evidence on matters that are unquestionably within his knowledge. But it does seem fair at all events to say that in an accident case where the defendant was himself the driver of the vehicle, the driving of which the plaintiff alleges was negligent and caused the accident, the court is entitled, in the absence of evidence from the defendant, to select out of two alternative explanations of the cause of accident, which are equally open on the evidence, that one favors the plaintiff as opposed to the defendant. Now, this decision was dealt with subsequently by the Supreme Court of Appeal in Jordan's case in 2004. That appears as item 6 in our heads of argument. Farlam JA, Mtiani JA, and Mutata AJA presiding. And the court held at paragraph 20 with reference to the Gallant decision. And I'm reading the relevant part after it quoted Gallant. It says, in considering which of the possible inferences is to be preferred in this case, it is trite law that the court may, by balancing probabilities, select a conclusion which seems to be the more natural or plausible conclusion from amongst several conceivable ones, even though the guarantee of a conclusion is not only the reasonable one. So the court is facing the conclusion that favors the party alleging and that doesn't favor the party who refuses to make full and material disclosure. It, in essence, is drawing an inference against the party who has unquestionably the evidence before them, within their mind, within their control, within their possession, but refuses to provide that evidence. Now, let me explain what that means in the present case. If your lordship is satisfied that on a balance of probabilities, there are two equal possibilities. The one possibility suggests that there is a link between two equal possible reasonable interpretations. If the judge is satisfied there are two reasonable interpretations regarding the link between Mariette van der Linde de Klerk, the one interpretation suggests that there might be a link, the other interpretation suggests that there might not be a link. If the judge is in that 50-50 position, this court can draw an inference against Mariette van der Linde de Klerk to break that deadlock and choose between those two reasonable propositions, choose the one that favors the complainant because the respondent refused to expose herself to cross-examination. The inference is if she did, she would damage a case. Now, Justice Makume, that presupposes, as I say, there are two reasonable cases on the evidence. We submit we're not even in that position. We submit that on a conspectus of the evidence, the eighth respondent has no construction, has no reasonable construction on the evidence to suggest that there isn't a link. We have identified two reasons why. The first, that she admits as much through a lawyer's correspondence on 4 occasions. The second is that cross-examination, her version is put that she is indeed a Facebook user and she posted on Facebook. And the third we're saying is this Gallant type inference. It's a factor you must take into account when assessing the evidence and deciding whether a link has been established. We say the factor that you should have regard to is that she refuses to get into the witness box even though she was present in circumstances where an explanation is cried out for. There's a further factor which demonstrates this link, Justice Makume, and it is that Mr. Pond demonstrates repeatedly what the funnel approach was that was employed to satisfy the TCA, that there was a link between that username publishing the impugned comment on the one hand and the eighth respondent on the other. And this funnel process is dealt with in our heads of argument from paragraph 165 onward. And what is the funnel process? I'll refer you to the transcript where he sets it out very plainly, Justice Makume. If I could refer you to the transcript at page 7 726. That's where it commences.
Yes.
Mr. Winks at line, I think it's 15, says, can you explain to us how the TCA went about identifying who to take legal action against? Mr. Pon, sure. So the process in which we identified the perpetrators, respondents, we used a funnel approach because there was a lot of, as I mentioned, racist comments. So there was a couple of hundred of them, and we needed a way. We could not go for all of them. Let's just put it in short. Mr. Winks interrupts him. Sorry, just so that I understand your testimony, you say there were hundreds of them. You're talking about Facebook pages of Carte Blanche and Karoo Donkey Sanctuary, right? Mr. Pond, that's correct. So these are hundreds of comments on Facebook pages of Carte Blanche and Karoo Donkey Sanctuary. We formed a team. The team was, and then he proceeds to identify the team at page 23, line 23, Mr. Winks. And what did you instruct this team to do, Mr. Pon? So the team would work filtering out all these names, starting from the hundreds of names. They had to go and look which were the most racist, the most genocidal, violent, insulting comments against the Chinese community or against the Chinese people as well. Then they had to filter those out. At line 11 on page, on page 728. The next stage, they would get the comments and the profile pictures. In other words, the pictures on the post. They had a little picture of a person next door to the comment. They would look at that picture and go to those people's pages, Facebook pages, and try and find out more information about those people. Mr. Winks, what kind of information? So that information could be showing, Mr. Pond, so that information could be showing perhaps where they lived, where they worked, perhaps their ages, the cities they lived in, any information that could really, I mean, there were two objectives in this phase, in this stage. The two objectives were confirm this is the person, identify the person, and number two, try and find an address which we could eventually send the papers to, serve papers to. So they would, in this is the first process, they would go to Facebook. They would then also go onto the internet and do a search for that person's name. When they found this person's name on the internet, you'd get a list of different results. They would click on those results. It would take them to other pages. One of the typical examples they would take them to is one of the typical examples is they would take it to a site called LinkedIn. And then he explains what LinkedIn is. And at page 730, okay, Mr. Pond continues. Okay, so I can search LinkedIn and look for other individuals that are in my similar line of work in banking. I can find somebody that I may be looking for, someone to do a website I can search for. It's a real business platform where you can find a lot of information. For me, that I can find information. It's a site where I can put my CV on so people can find a lot of information about me. It's a site I can use and I can get contacted on for people saying that I see this is what you do, Mr. Pon. They can contact me. These are really platforms where I can share. I'm at 731. I can share my details with people. I can allow them to contact me. It provides a lot of information about my work and the things I do in my profile and with lots of profiles that I've seen. And when I reach out to people, they have a nice picture of that person as well. You get to see who you're dealing with. And Mr. Wing says, if you search someone else's name on LinkedIn, it will provide me with their information if they're on LinkedIn. Yes. Mr. Winks continues as part of this funnel process. He's exploring at 732. You told us that you had instructed the team to search the internet for the names that had appeared in the comments, the names of the authors of the comments. Is that right? Mr. Pond, that's correct. Mr. Winks, and then you would find other websites that referred to those names. Mr. Pond, correct. And one of those websites was LinkedIn, correct. Okay, and you said the purpose of this was to identify, to verify. Mr. Pond, yes. To verify the identity of the person. Correct, to confirm the identity and the location of the person and serve them papers. Correct. Then Mr. Winks takes Mr. Pon to a trial bundle, page 602, and it's a document compiled by the TCA. It highlights the analysis and the process in which the team went through to ascertain and make sure they were finding the right people. And Mr. Pon refers to that document. He says, so the purpose of the document was twofold: to make sure that people we were going to be serving notices to were the right people that we were going for, basically for cross-referencing, and make sure that those people were the people we were going after. And secondly, to find out where we could serve them. Mr. Wing said, what would happen if the information provided to you by the team was insufficient? Mr. Pon, this is important, what he says here, Justice Makume. He says, so I'd instructed the team, the TCA team, that there were 3 reasons. There were 3 things that I said to the team about when they were compiling this list. Number 1, you're not representing yourself. You represent the Chinese community when you're doing this. So make sure you get it right. Number 2, it is a serious matter. You need to treat this very seriously. And then number 3, I said, get it right, because I was worried that if I get it wrong, we may be sued. So when we were going through this document, I saw certain names that didn't correspond, or said, oh, they said this is vile, this is terrible, and potentially even worse comments than the 12 respondents. I said to the team, whilst it pains me that this is a horrible comment, and I really would have liked to take these people to the court, we cannot. We do not have any other information to cross-reference with, and so we eliminated those persons. That, in essence, is the funnel system. You will see, Justice Makume, the funnel system in the trial bundle, and in this document, which has been referred to in this excerpt from the transcript, was referring to this document at 602. It's one of the documents that the TCA personnel under Mr. Pon produced. And you'll see this document in the trial bundle at page 602, and in particular at page 604 and over the page at 605. They've got a profile for Mariette van der Linde de Klerk. They include the quote and they have references to where they've verified details about her on the internet. They've got her Facebook page, they've got a LinkedIn profile, they've ascertained that she lives in Johannesburg, she attended the Northwest University of BCom, she's a manager she was at the time, a manager for finance, coke and chemicals, ArcelorMittal. Now, it is part of the verification process that was embarked upon, this identification process, that satisfied the link, insofar as the TCA was concerned, between the username and the 8th respondent. That funnel process was repeatedly challenged in cross-examination by Mr. Garvey on no fewer than 7 occasions, Justice Makume. He tried to shake Mr. Pon on this. When one has regard to the conspectus of evidence, it is clear that Mr. Pon was consistent. He was demonstrably consistent. He demonstrated that the TCA was rigorous in enforcing this funnel process. Now, again, coming back to that gallant decision and the inference against the 8th respondent in circumstances where she elects not to give evidence and nevertheless puts up a version that she didn't make the comment. One would have thought that it would have been extremely easy for the 8th respondent to say, that's not me, that wasn't my profile, that wasn't my LinkedIn profile, that wasn't my picture, those weren't my details, that wasn't my employee at the time. She doesn't do any of that. And it is yet, excuse me, that funnel process is yet a further string in our bow demonstrating the link between the username and Mariette van der Linde de Klerk. Mr. Pon also, in the course of the identification process in his testimony, demonstrated that the Facebook account that the TCA had identified for Mariette van der Linde de Klerk had been deactivated after service of the process. He also gave evidence to the effect that the photograph displayed on the Facebook account contained the face of a person whom he recognized as being present in court during the commencement of the inquiry in March. Again, not a coincidence. He also gave evidence to the effect that after the complaint was served on the 8th respondent, the LinkedIn account that the TCA previously identified to Mariette van der Linde de Klerk was deactivated. Again, no coincidence. Miss Marietta van der Linde de Klerk, the 8th respondent, confirmed her full name under oath as a double-barrel surname, a relatively unique name. There was no other than the 8th respondent showing up in the TCA's internet searches with this unique name. During the inquiry, one gave evidence that he searched for the unique abbreviation of her name, Marietta Vidi Linde de Klerk. He found nothing on the internet except an Instagram account with that specific username and showing of the 8th respondent he has in court. The very evening after Mr. Pond testifies about the 8th respondent who he says he saw in court and links her to the Instagram account, the account becomes closed to the public. Again, no coincidence. The only reasonable, plausible, and realistic inference to draw in the circumstances is that the 8th respondent was desperately trying to cover her tracks. She inadvertently, as a result, confirmed this link. The probabilities continue to stack up against her, demonstrating this second proposition, namely that the username Marietta van der Linde de Klerk, which published the impugned comment, is the exact same person as the 8th respondent. For those reasons, we submit, Justice Makume, that on a conspectus of the evidence, it is not only clear on a balance of probabilities, but it is absolutely clear that the complainant has established the link. That takes us to the third submission, Justice Makume, in order for the complainant to come home against the 8th respondent. We've demonstrated that the comment was published when it was published on the Carte Blanche Facebook page by that username. We've demonstrated, secondly, that that username was effectively the 8th respondent. And the third point is we now deal with the question of what do these words mean? We have dealt with this at paragraph 176 onward. I don't mean to belabor the point ad nauseum, but I'm just going to highlight some key aspects. When the comment refers to Chinese in SA, it's obviously referring to Chinese people in South Africa. And Mr. Pon understood that phrase to mean the Chinese that are here, meaning myself, my family, my children, my friends, my community. Although I'm referring Justice Makume to Mr. Pon's understanding, that's because of his context, but it's an objective, reasonable interpretation. We submit that the objective, reasonable interpretation of a person in the position of Mr. Pon and other Chinese representatives who gave evidence demonstrates very much the meaning that we contend for. The words "get rid of" means to relieve or free oneself. Mr. Pon understood these words as I took it as insects, like vermin, to get rid of something like a pest. And again, just feeling the dehumanized. The words "not welcome" speak for themselves. Mr. Pon gave evidence to the fact that it took him back to his past, where he felt they weren't welcome in South Africa. It hurt me. He said, my kids are grown up here, they're 5th generation. It would devastate my children for someone to tell them you're not welcome here. We've dealt with that evidence. He pointed out the hurt that they experience, the Chinese community, and he in particular, when someone says that to him. The words "steal our economy" allude again to the racist representation of Chinese people as foreigners, as aliens, coming in rapaciously to economically exploit and steal, notwithstanding the fact that they've been here for several hundred years. Mr. Pon gave us his explanation of that. The reference to stealing dogs and pets is a recital of the decades-old racist trope that Chinese people eat domestic animals, which Mr. Pon attested to was a common insult deployed against him as a child. And the reference to stealing rhinos is again a recent racial stereotype that Chinese people as a race are collectively responsible for the poaching of rhinos and their horns. And again, Mr. Pond dealt with it. We submit that the statement constitutes hate speech along the lines reworded in Kwelani. We have set that out very fully in our heads from paragraph 185 onward. The reference to Chinese is in the comment is a reference to a prohibited ground of race or ethnic origin. The words were clearly evidencing an objective intention to be harmful or to incite, or an objective interpretation to be harmful or to incite harm. Distinguishing between the we and they were denounced as aliens and foreigners intruding into South Africa to strip it of its economic benefits like a parasites. These words clearly encourage people to be hostile to Chinese people, to expel them from South Africa. They seriously impaired the Chinese people's dignity, their emotional and psychological well-being, their self-worth and their sense of acceptance, and they go a long way to undermining the national unity and reconciliation project of South Africa insofar as it concerns Chinese people. Insofar as harassment is concerned, we submit that the words constitute unwanted conduct. It is serious, it demeans or humiliates, creates a hostile or intimidating environment for the Chinese people, and it's related to their membership of a group characterized by one or more of the prohibited grounds. In other words, a group characterized by race or ethnicity. And that's precisely why it falls within the prohibition against harassment. And we also submit that it falls under the prohibition against unfair racial discrimination under Section 7A, where we deal with that at paragraph 201 onward in our heads. We stand by those submissions, Justice Makume. In relation to the question of remedies, we have sought a number of remedies against the 8th respondent. We have addressed that at paragraph 207 of our heads. I'm not going to repeat them verbatim. In particular, at paragraph 209, we sought an order constituting the following: that the 8th respondent's words are declared to constitute hate speech, harassment, and unfair discrimination against people of Chinese race in contravention of sections 10, 11, and 7 of the Act, that she's interdicted and restrained from publishing the same or similar words. Within 30 days, she shall publish an apology, and she shall pay a fine, damages rather, in the amount of 150,000 Rand to the Hongning Chinese Aged Home, and she'll attend a racial tolerance class. We also submit that she should be ordered to pay the complainant's legal costs. I will, however, address you on the question of costs right at the end, after my learned friends, Mr. Winks and Ms. Hardy, have dealt with the 4th respondent and the complainant, the confessors and defaulters. Justice Makume, do you have any questions for the complainant insofar as the case against the 8th respondent is concerned?
I just wanted to take you back to perhaps the proviso to section 12. Can I say that section 12, the
proviso to section 10, Justice Makume?
Well, yeah.
Referring to section 12.
Yeah, I think I marked it somewhere, and I'm trying to get to. Well, the fact that the 8th respondent did not raise a justification for publishing those words. Now, the impugned words. Now we know that in the letters from Nolte, yeah, I come on page 24 for them. He said, on paragraph 55 of his, none of the respondents in this matter has invoked the defense in the proviso to section 12. But I'm saying in the letters that were quoted, I believe that she says that she did not need to hurt people of Chinese origin, but the people who were responsible for the slaughtering of the donkeys. If one was to accept that, would that amount to her having raised? I know she did not give evidence. Her having raised a defense to say that it was in the public interest, to say that people who slaughter these animals in this manner are horrible people or something of that nature.
Yes, Justice Makume, could I deal with that by referring you to two sections in our heads?
Okay.
The first is section 10, dealing with hate speech, where we provide the revised provision of section 10. You'll see section 10 is prefaced with the proviso. It says subject to the proviso in section 12. Section 12, as appears from the Act, is dealing with information and advertisements that are publicly disseminated or broadcast. That has no application in the present matter. Apologies, you were still looking at that. That has no application in the present matter. Section 12 hasn't at all been raised by any of the respondents. It relates to information and advertisements. It doesn't apply at all. In fact, we deal with it at paragraph 54 of our heads. The reference proviso in section 12 is that bona fide engagement in artistic creativity, academic and scientific inquiry, fair and accurate reporting in the public interest, or publication of any information, advertisement, or notice in accordance with section 16 of the Constitution is not precluded. It hasn't been raised by any party. The point you're referring to, Justice Makume, is that can the correspondence of the 8th Respondents Attorney, Nolte Incorporated, be remotely bent to construe it as raising a section 12 proviso? In other words, to say that this was a bona fide raising for purposes of artistic creativity or academic and scientific inquiry, fair and accurate reporting in the public interest, certain public information that's protected by section 16. So you want to know whether that proviso in section 12, even though not expressly raised, can be used to assist or can be construed as being raised by the 8th respondent. If you bear with me a second, we have dealt with this in the 8th respondent's admission. So if you have a look at paragraph 173 onward of our heads of argument, you will see that we quote from the relevant correspondence. And in particular, you're referring to the letter of 22nd June 2017, where Nolte Incorporated, writing on behalf of the 4th and 8th respondents, states that the 4th and 8th respondents are extreme lovers, I quote, are extreme lovers of animals, and was shocked at what was shared on Facebook. And their comments were aimed at those responsible and not the Chinese public in general. Now, if you look at their comment, the 8th respondent's comment, and I've pulled it up, it's reproduced at paragraph 157. The comment is, we need to get rid of Chinese in South Africa. Justice Makume, by any stretch of that imagination, it doesn't constitute artistic expression. It doesn't constitute free speech that is not hatred espousing. It doesn't constitute scientific inquiry, and it certainly doesn't constitute interest expression in the public interest that should be protected. On the contrary, it is, as one looks at it, we need to get rid of Chinese in SA. They're not welcome. They steal our economy, dogs, rhinos, and now donkeys. That comment as we've dealt with the meaning in the context, demonstrates a need to get rid of Chinese in South Africa. They're not welcome. You just start out with that opening line and you'll see that the meaning can never, ever fall within the purview of the Section 12 proviso. Not that Mr. Garvey has ever contended that, nor has any evidence been led in that regard, nor has any argument at any point in any time during the course of this very lengthy inquiry being made suggesting that it falls within the purview of Section 12. Indeed, Mr. Garvey's heads on behalf of the 4th and 8th respondent don't allude to Section 12 at all. And when one looks at our analysis of the words in this context, you'll see we deal with it from paragraph 185 onward. I've run through that rather quickly in the interests of time. But when your lordship has regard to the particular words used, we parse those words, we subject them to careful analysis, we deal with them in the context, and we point out that those words meet the threshold of hate speech. They are referring to Chinese en masse. They're referring to prohibited grounds of race or ethnic origin. They are demonstrating intention, clear intention to be harmful, to incite harm. They're distinguishing Chinese people by rendering them to be the proverbial other, distinguishing between we and they, those were the words employed. And by using those words, we and they, she's effectively in context, denouncing them as aliens, foreigners, intruders. She's painting them not as economic contributors, but parasites and thieves. She's painting them as not only as poachers, but she's perpetrating and propagating the false stereotypes about Chinese people. The stereotypes I've already described to your lordship. And these words clearly in their context encourage people to be hostile to Chinese people, to expel them from South Africa. As a result, I beg your pardon, Justice Makume?
No, thank you. I think you have responded to that.
Okay.
I just want to, get into the remedies. Now, you say on 209.4, part of the remedies is that within 6 months, their 8th respondent shall pay an amount of, is it 6 months from the date of judgment? Or
it would be, that is with respect to good question, Justice Makume, it would be 6 months from the date of judgment.
Okay. Okay, no, thank you. If that concludes your submissions for now.
I just wish to now very, very briefly deal with some of the submissions made by Mr. Garvey.
Yes. We
will deal with these more fully in written reply, and we will send the relevant references to the transcript to you, Justice Makume. I don't have time to run through all of them with you in this oral hearing. One complaint is that the 8th respondent sought the original comment but didn't get it. Now, there are more than 15 references in the record where this is dealt with. And unfortunately, you will see that the 8th respondent is incorrect on the facts. It was very clear on the evidence that the original message was deleted from the Carte Blanche Facebook webpage. The original message of the screen grab or the screen munch or the screenshot, however one wants to refer it to, or however one wants to refer to it as, that was provided to them. They had the original phone. They analyzed the phone with which that screenshot was taken. They and the screenshot was stored on that phone. So repeatedly we ran into this difficulty with them, but they were given the relevant original to the extent that it was in our client's possession. The second complaint is that Ms. Sadler confused screenshot with photograph, but with respect on the facts, when one looks at the transcript and assesses the evidence holistically without cherry picking little context, little sentences without context, it becomes plain that wasn't Ms. Sadler's evidence. She made it plain that a screenshot is not a photograph. A further complaint is that the court refused to allow the 8th respondent to lead Jason Jordan as an expert witness. And with respect, Justice Makume, that was dealt with in the transcript. It was dealt with very extensively. My learned junior, Ms. Williams, provided argument to you in that regard, full argument. And after hearing full argument, the court refused to allow the introduction of expert evidence by the 8th respondent several months into the inquiry, after the inquiry had started, and 6 days into the inquiry with no notice whatsoever. And that is dealt with in the transcript. I'll have to, in our replying heads, give you the relevant passages in that regard. A further point is the point that the admissibility of evidence has not been determined, and the decision of Ndlovu is cited. I find this a risible point, Justice Makume, and I chuckle a little at the point that is being raised. Your Lordship will recall that Mr. Garvey, on behalf of the 4th and 8th respondent, had a number of objections to evidence, very technical objections. And after the complainant's case was closed, the complainant said, look, Mr. Garvey has alerted us to this concern of his that apparently the court hasn't issued a ruling on questions of admissibility that's final. We invite the court to do so. You'll recall that in his submissions to the court, Mr. Garvey sought to shout me down. He approached the court and spoke to the court in a way I've never seen in 17 years of practice. He interrupted me repeatedly. He bullied and browbeat the court. And he, in effect, on behalf of his clients, the 4th and 8th respondent, absolutely refused to have the court deal with any of these questions of admissibility. It therefore doesn't lie in his mouth now to complain, as we pointed out at the time, that the questions of admissibility were not dealt with. He is the author of his own misfortune, and he went in eyes wide open. The only reasonable inference to draw, Justice Makume, is that he was contriving on behalf of the 4th and 8th respondents a procedural objection. That is nothing less than an abuse. If he is persisting with the point, well, then one simply refers him to Regulation 10.7 of the regulations. It appears in our authorities bundle at item 2. Regulation 10.7 states as follows: save as is otherwise provided for in these regulations, the law of evidence, including the law relating to competency and compellability as applicable in civil proceedings, applies in respect of an inquiry. But here's the important proviso: provided that in the application of the law of evidence, fairness, the right to equality, and the interests of justice should, as far as possible, prevail over mere technicalities. So Mr. Garvey is suggesting on behalf of the 4th and 8th respondent that the law of evidence requires, and he cites the Ndlovu decision, requires this court to have made a ruling before the close of the plaintiff's case. Now, it matters not that we asked immediately afterward. That's a minor technicality. Insofar as he wanted that ruling, he could have sought it from the court. What did he do? He strenuously resisted that ruling. He knew full well that he is resisting the ruling only to raise it as a procedural point afterward. That is an abuse. Fairness, the interest of justice, and the right to equality of the complainant demands that this technicality that has been contrived and conjured by the fourth and eighth respondent be simply overridden. It should not be able to trump the fairness, the right of equality, and the interests of justice in this case, in other words, this technical argument. I don't think anything more need be said on that technical argument. I did find it rather surprising. I also want to point out that it similarly underscores the abuse that the fourth and eighth respondent have been engaged in, and I will address your lordship on that score when I deal with the question of costs. Those then are the submissions on behalf of the eighth respondent. My learned friend, Mr. Winks, will deal with the submissions on behalf of the complainant against the fourth respondent, and Ms. Hardy will then deal with the confessors and avoiders, confessors and defaulters.
Yeah, before you step down, I'm trying to look at the fourth and eighth respondents here and trying to find out whether is there anywhere where they deal with the issue that you remember at some point it was argued that Ms. Sadler was not an expert witness, and Ms. Sadler said that she was a factual witness, she was not testified as an expert witness. Is there somewhere in their heads where they raise that issue, or has it been abandoned?
They deal with the question of the eighth respondent, and he should have been led as an expert witness. I don't know. They introduce Ms. Sadler's evidence there, and they say that she wasn't in a position to deal with this, and the proposed witness, Mr. Jordan, would have spoken to those issues. That appears at page 5, and you'll see just below it, paragraph 13, they introduce Ms. Sadler's evidence in chief there. And over the page 14, 15, and 16, where they're dealing with the failure to allow, the alleged failure to allow Mr. Jordan's evidence in, and in contrast, the alleged difficulties with Ms. Sadler's evidence. I don't know if they've dealt with it in any other spot. They might well have, but the point about Mr. Jordan's evidence is simply the following. And again, I'm recapping what was already addressed to your lordship and upon which your lordship issued a ruling regarding Mr. Jordan's evidence. Your lordship will recall that a day before the resumed hearing, they provided a signed affidavit by Mr. Jordan. 2 days before that, they provided an unsigned affidavit by Mr. Jordan. So it's 3 court days before the resumed hearing, 7 or 8 months after the inquiry has started, and 6 days into the hearing, they attempted to introduce this affidavit and to cross-examine on the basis, cross-examine Mr. Pond based on this proposed affidavit evidence. There was no explanation for the extremely belated attempt to introduce the proposed expert evidence. There was no application for condemnation. There was complete non-compliance with Rule 36(9). The proposed evidence had not been put to Ms. Sadler, whose evidence had already been completed. The response that Ms. Sadler wasn't an expert and therefore wouldn't have anything to say in the response was presumptuous. This is because whether or not Ms. Sadler could respond would only be determined if and when those allegations were put to her. And it wasn't possible because her evidence had already been completed. Also, the complainant had no opportunity to consult in relation to the proposed expert evidence, including with another expert, or to prepare Mr. Pond, or to adduce other facts through further witnesses. And the introduction of affidavit evidence is not there for the taking. It must comply with Rule 10(6) of the regulations, which required that the complainant agreed, which required that the affidavit needed to be signed, which required that it had to be provided 7 days before the commencement of the inquiry. not 8 months after it commenced and 6 days into the inquiry. And it didn't lie in the 8th respondent's mouth to complain that Mr. Jordan should have been allowed to give affidavit evidence and be cross-examined by Skype in circumstances where the 8th respondent herself refused to indicate whether she was objecting to the proposed affidavit evidence of the 3 complainant witnesses, Ms. Yap, Ms. Wing, and Professor Parks, who had been flown in especially from the US and whose witness statements had been filed months in advance, let alone a day before the court hearing. So with respect, Justice Makume, I don't see any merit in the point. I don't know where it takes the 8th and 4th respondents, but no doubt you'll hear from Mr. Garvey.
No, my question was actually directed at paragraph 5 of their heads. They say the 8th respondent objected to the evidence of Sadler on the basis that same was not opinion evidence, but also considered admissible hearsay. When objection was raised in court, the complainant sought the inadmissible hearsay evidence to be provisionally admitted. The issue that they raise is, I want to know, they not seem to be insisting that, in fact, when she gave evidence, she was giving evidence as an expert witness, but as a factual witness. Am I right?
We repeatedly dealt with an objection that was raised by Mr. Garvey. The objection was to the effect that Ms. Sadler's evidence is of an expert nature. Our response there to whenever the objection was raised was no, Ms. Sadler is not giving evidence as an expert. She's giving evidence as a lay witness. I don't know where they wish to take this even further, or how they wish to take this even further. Justice Makume. Once we hear from Mr. Garvey, perhaps we can deal with it in the reply.
Yes, no, that's fine. Are you done with your submissions for now?
I am. Thank you, Justice Makume.
Before either Advocate Wings or Ms. Williams comes in, can we take a comfort break? I see it's 11:50 now. Can we take a comfort break for about 15 minutes and come back at 12:10?
Thank you, Justice Makume.
Thank you.
Definitely.
We adjourn the court and judge for now. Thank you.
Thank you.
Yes, good afternoon. Are you ready, Advocate Wings?
I am, my lord.
Thank you. We proceed. You're going to be dealing with the case against the 4th respondent, am I right? Advocate Wings, can you hear me? You're frozen now.
Apologies, my lord. Very delayed. I can hear you now, my lord.
Yes, I can hear you now. You may proceed, sir.
Yes, my lord. So I'll be dealing with the 4th. Thank you, my lord. I'll be dealing with the 4th respondent, as Mr. Ismail has said. That's David Lai-Hong. My lord will see that we've addressed the case against the 4th respondent from pages 41 onwards of our heads of argument. I won't repeat the heads of argument. I'll just highlight the points that are particularly relevant to what's been raised, the limited degree of what's been raised by Mr. Garvey in his heads of argument. Now, it's not in dispute that the 4th respondent published on Facebook the following words. Personally, I say wipe them out. I'd be the first to be there. It's not in dispute that he said that. He disputes that this, he disputes two things. He disputes that this was his full comment, and he accuses the Chinese Association and its representatives of having manipulated or altered or edited his comment to suit their own purposes. And then he disputes that it referred to Chinese people, that the word them referred to Chinese people. Now I'll deal with each of those in turn. The complainant has never taken issue with the fact that this is a selected quotation from his full comment. Now, my lord, I'm sure would have sat in many cases that concern expression. Defamation cases are probably the most numerous of them. There are also intellectual property cases where copyright is infringed or alleged to be infringed, where somebody has plagiarized another person's written work. Now, in all of those matters, your pleadings will identify the objectionable portion of the words complained of. So somebody writes a nasty book or a book that contains 2 nasty pages about me. I'm not going to attach the whole book to my particulars of claim. I'm going to quote the portions that defame me. There's nothing wrong with that. There's absolutely nothing wrong with that. He doesn't dispute that these words, personally, I say, wipe them out. I'd be the first to be there, double exclamation mark, appear in his comment. He published those words. Now, what we said in our complaint form to the Equality Court was that the 4th respondent stated inter alia the following words. There's nothing untrue about that. There's nothing inaccurate. There's nothing improper about that. We then adduced screenshots which showed the full comment. Subsequently, he adduced screenshots which confirmed that this was an absolutely accurate. The batch that we had produced once Emma Sadler had retrieved them from her phone were absolutely accurate. They captured his comment 100% identically to the way it appeared in his activity log and the way it appeared on Facebook when he made it. So he made this comment. Now, so on the ordinary rules of pleading in civil cases, there's absolutely nothing wrong with this. Even in a criminal case, if you were to accuse somebody of inciting violence in a speech, you would identify those passages of the speech that incited violence. You don't reproduce the whole thing. Now, I'd like to take, my lord, to some comments about the relevance of how the pleadings are formulated in the Equality Court. This is a unique court. Mr. Ismail took my lord to some of the legislative and regulatory framework about why this is a special court. Now, Mr. Garvey and his clients are fundamentally mistaken about the nature of proceedings before the Equality Courts. And that's been demonstrated throughout the proceedings. Now, Equality Courts do not simply adjudicate adversarial disputes on the basis of technically formulated pleadings. They are expressly enjoined to be informal and inquisitorial, where substance is supposed to triumph over technicality. And this is because, as the Supreme Court of Appeal held per Nafsa JA in Manong, and the reference is Manong and Associates, Pty Limited versus Eastern Cape Department of Roads and Transport and others, 2009, Volume 6, SA 589 SCA, paragraph 53. This is what Justice Nafsa had to say. It is abundantly clear that the Equality Court was established in order to provide easy access to justice and to enable even the most disadvantaged individuals or communities to walk off the street, as it were, into the portals of the Equality Court to seek speedy redress against unfair discrimination through less formal procedures. And accordingly, applying this in Woodway's CC versus Valley, that's VALLIE, and the reference is 2010, Volume 6, SA Law Reports 136 WCC. This was the Cape Town High Court. Zondi J held as follows. It is clear to me that the Act creates an informal and inexpensive platform for the adjudication of unfair discrimination disputes. It marks a shift from the conventional way of litigation, which emphasizes elegance in the formulation of pleadings. It creates a space for the victims of unfair discrimination to tell their stories so that systemic inequalities and unfair discrimination, which, as the preamble states, remain deeply embedded in social structures, may be eradicated. The promise of equality and easy access to justice, which the Act seeks to fulfill, would never be realized if litigants in unfair discrimination cases were expected to be meticulous in the manner in which they plead their causes of action. End quote. And that's paragraphs 36, 37, and 38 of Zondije's judgment. So this technical objection of theirs elevates form over substance very clearly. It's a technical objection. It's a vexatious objection because he's conceded that these words were published by him. He simply says, oh, but in the Form 2 complaint, you left out these introductory words, thank you, Jono. And this question about alteration, or this accusation of alteration and editing, was put to Mr. Pon by Mr. Barrenser at least 15 times, despite the interventions of the court saying he's already admitted that words were left out. Why are you going on about this? And Mr. Barrenser kept hammering on about it at great cost to the clock and the patience of everybody concerned, and the stamina of the witness, where it was never in dispute that the comment on Facebook began with the words, thank you, Jono. Now, after being pressed through objections and intervention from the court, Mr. Barrenser finally asked Mr. Pon, doesn't that change the meaning of wipe them out? And he said, no, it doesn't change the meaning. So here's the dispute, is that Mr. Horn says that because I used the words, thank you, Jono, I could never have been referring to Chinese people. I simply don't follow that argument logically, my lord, with respect. What difference does saying thank you, Jono, have on the meaning of personally I say wipe them out? The only question is who is meant by them? And then that's where we need to get into the context. And the context, Mr. Horn kept going on about the context through Mr. Barrenser and also in his affidavits before the court, saying, no, there's a context, there's a context. But the context, he never explained how the context helps him. The context, as we've explained at length in our heads of argument and also in the evidence of Mr. Pon, is against Mr. Horn. And that's because now the post he was commenting on was this Mail and Guardian article entitled, Why Are Gangs Killing Our Donkeys? And then there was a link to that article. So he's commenting on this article by the Mail and Guardian and the Karoo Donkey Sanctuary post referring to the article. Now, this context is obviously important. What a reader would see, and remember the test, as Mr. Ismail indicated in his address, the test is objective under Kwelane. We're dealing with civil delicts. The subjective intention of the writer is irrelevant. That was confirmed as far back as AfriForum versus Malema, and it was confirmed now by the Constitutional Court in Kwelane. Subjective intention of the speaker or the writer is irrelevant. What is relevant is the reasonable person, how the reasonable person reads the comment in context. Now, what the reasonable reader will see when he's looking at that comment, and this is Mr. Horn's own documents, you'll see the Karoo Donkey Sanctuary's post. And then you will see the Mail and Guardian article. And then you will see the other comments published by other Facebook users, which precede Mr. Horn's comment chronologically. So that is the totality of what a reader would see surrounding the fourth respondent's comment. Now, those materials are replete, all of them, with references to China and people of Chinese race or nationality or ethnicity. No other race or nationality is mentioned in any of this material. So the Karoo Donkey Sanctuary post, it says, why are gangs killing our donkeys? And then the underneath the photograph, the caption says, it is believed they are being exported, slaughtered illegally, and exported to China by a syndicate to China. Then the accompanying statement added by John O'Sherwin of the Karoo Donkey Sanctuary says, in the region of 5,000 donkey skins destined for the donkey hides trade to China, seized and impounded, perpetrators under investigation. So that's what John O'Sherwin says. He says these donkey skins are destined for the donkey hides trade to China. He doesn't actually say anything about gangs. He says perpetrators under investigation. The imputation is clearly that Chinese people are responsible. At the very least, they're the consumers of this illicit trade. Then there's the link to the article that's posted there by Mr. Sherwin. Now, the Mail and Guardian article is also replete, if my lord turns to page 46 of our heads of argument, you will find the references, the quotations from the article, where the references are made to the Chinese as being responsible for this illegal slaughter and trade. So it says, for example, I won't go through all of them because they're on record, and I don't intend to repeat anything from our heads of argument, but it says, the opening paragraph of this article says, the discovery of more than 5,000 donkey hides in a shack and a metal container in Benoni could blow the lid off the illegal slaughter and trade of the animal's meat and skin, allegedly by a Chinese syndicate. And then my lord will see the references to Chinese guys used for medicinal purposes in China. They, Asian men, these skins belong to the Chinese. The demand for donkey hides spiked in China. A container hides, by the time a container reaches China and is sold on their markets, it is worth approximately 8 million rand. So throughout the article, the words them and their and they are referring to Chinese people. Now, then there are the comments by the other Facebook users, which appear alongside Mr. Horn's comment and in fact precede them, because these were on January 21 and his was on January 22.
It is along Mr. Horn's comment.
Sorry, Mr. Horn's comment.
Yeah, so I thought, yeah.
Mr. Horn, the fourth respondent. So his appears in a context, it appears in a sea of comments, where some people simply express their anguish at what is being done to the donkeys, not blaming it on anybody. They simply say how dreadful, the suffering must be abhorrent. So if we turn to paragraph 120 of our heads, you'll see these comments replicated. And the reference you'll see is in the footnote. So Judy Robinson says, how dreadful. But then Lisa Smith says the Chinese are just barbarians and have no empathy whatsoever. She's not saying the gangs or the perpetrators, she's saying the Chinese, the racial group. June Johnston on the following page says, name, shame, and deport these greedy Chinese. They come to South Africa and plunder our wildlife, etc. Then Charmaine Scully, 3 comments down, says, China won't stop till they have it all. Denise Wilhelmi, Chinese nationals raping this country. Lorna Grant, China, eat your bloody selves. We don't want you here. Ruan Verwey, stop buying from these Chinatowns. It's the only way to send them home. I just don't support them. Niels van der Walt, the sad news is that they are slowly but surely buying Africa with their investments. Brett Parrish, F the Chinese. They are raping this continent. Now, Jill Walker, this is beyond comprehension. The Chinese just keep their sticky fingers off an effing thing. Rot in hell, the lot of you. And then on the following page, David Clive Horton, the 4th comment on this page, the following day, January 22, says, Jonathan John O'Sherwin, thank you, and a couple of emojis. And then he says, personally, I say wipe them out. I'd be the first to be there. Now, we submit that the reasonable reader will very clearly conclude when they read this series of comments that the 4th respondent is referring to the same them as the Mail and Guardian article refers to, and as the other comments refer to. The only people being blamed in any of these materials is the Chinese, the racial ethnic group, the Chinese. There's simply no escape for the fourth respondent. And there's no real attempt even in Mr. Garvey's heads of argument to deal with any of this contextual evidence. He simply doesn't deal with it. He talks about the comment having been edited on page 7 of his heads of argument. We've dealt with that. It's a spurious objection. When Mr. Horn, the fourth respondent himself, has adduced evidence which shows he published these words, wipe them out. The only question is what those words objectively mean. Now then Mr. Garvey goes on about how Mr. Horn's in fact, all that Mr. Garvey says about this is on page 16 of his heads of argument, paragraph 56, where he says, it's respectfully submitted that the proposition in relation to the word them put by the complainant to Horn is with respect disingenuous and cannot be accepted on any interpretation as hate speech, and especially not in the context of the present matter. I don't even understand what that vague comment is supposed to mean. Doesn't explain the context of the present matter. Then paragraph 57, Horn further disputed under cross-examination that the word them is referring to the complainants as sought to be inferred by the complainant. Horn expressly responded that it's clear to him that he was not referring to the complainant or its members or any other nationality, color, creed, or religion, but the gangs responsible for the unlawful killing. Now, Mr. Garvey doesn't deal with the clear, unambiguous, and distinguishable judgment of the constitutional court, the highest court in Kwelane, which says Mr. Horn's intention, subjective impression is irrelevant. It's the objective test. Now, Mr. Garvey doesn't even acknowledge that the test is objective, and he doesn't confront that test. He doesn't present a defense to it. He simply makes a bold statement that, oh, well, Mr. Horn denied it, so therefore we must believe him. That's, with respect, not the question. It's not, as my lord will know from defamation cases, as has been applied in, for example, Nelson Mandela Foundation versus AfriForum, that, and in fact, all the hate speech cases, that the meaning of words is not something for a witness to testify about. The meaning of words, whether it's in a contract or a defamatory statement, is for the court, because it's a question of the objective person. So now, the fourth respondent accepted under cross-examination that any person who visited the post would have seen the other comments. This I've addressed, the reference is under paragraph 121 of our heads of argument. Now, let's look at the words wipe them out. So we submit that there's an absolutely unanswerable and unanswered case that this comment, objectively speaking, to the reasonable reader, was referring to Chinese people. Them is the Chinese. So he is saying, when he says wipe them out, wipe out the Chinese. So let's now go to the second question. So Mr. Ismail had indicated that there's a three-stage exercise in determining whether someone's committed hate speech. The first is, did they make the comment? The second is, was it based on a prohibited ground? So the first one, yes, they made it. Mr. Horn made it, we know that, it's not disputed. The second is, was it based on prohibited grounds? That's disputed. He says he wasn't referring to Chinese people. We say that objectively, which is the test, the comment was referring to Chinese people. That's the way the reasonable reader would have read it. Then the third one is, assuming that it is based on prohibited grounds, it's referring to a race or ethnic group, then does it meet the test for hate speech? So is it harmful or incites harm, or promotes or propagates hatred? Now, In our submission, it does both. And Mr. Garvey makes no attempt anywhere in his heads of argument to argue, as he couldn't, that the words wipe them out, if they are referring to a racial group, are violent, genocidal, and extremely hateful. We've explained in our submissions why the dictionary definition of wipeout is to destroy completely or eradicate, or to murder or kill. That's paragraph 128 of our heads of argument. So there can't be any quibble about what wipe them out means. And we haven't seen a quibble with our dictionary definition. No alternative definition has been proffered by Mr. Garvey. And it's perfectly consistent with the way Mr. Pon understood the words, but obviously it's a question for how the court and the reasonable person understands the words. So what is the test for hate speech then? We've gone through what harm means. Mr. Ismail has taken you to that under the Sutherland judgment in Khumalo, which was adopted by the Constitutional Court in Koilane. So by asserting that Chinese people deserve to be eradicated, these words encouraged people to be hostile and even violent towards Chinese people. It seriously impaired Chinese people's dignity, emotional and psychological well-being, self-worth and sense of acceptance, and it undermined national unity, reconciliation, acceptance, and social cohesion insofar as it concerns Chinese people. So in all three manifestations of harm that were articulated in Khumalo by Sutherland, as he was then, it satisfied the first leg of being harmful or inciting harm. It's obvious, my lord, that wipe them out is inciting harm. Now, did they demonstrate an intention to promote or propagate hatred? Again, there can't be any doubt that they did. They revealed an intention to inspire enmity and extreme ill will against Chinese people, which are the words used in Koilane, to abuse, denigrate, and delegitimize them, to render them lawless, dangerous, unworthy, and unacceptable, and to make them despised, scorned, denied respect, and subject to ill treatment. On that basis, and these are all the descriptions of promote and propagate hatred from the Constitutional Court's judgment in Koilane, which my learned friend simply has failed to deal with these elements of hate speech in his heads of argument. Something that needs to be said is that whether Mr. Horn believes he was doing something wrong or not, objectively speaking, he was pouring petrol on a raging racist inferno online. His was arguably the most violent of the comments that appeared on that Karoo Donkey Sanctuary post. The others were certainly more explicit about referring to Chinese people. Now, his was the most violent, and we submit the reasonable reader would obviously read it as referring to the same Chinese people as everybody else. But his then is even more serious because it calls genocidally for a group of people to be wiped out. My lord, I'd like then to move on to harassment, section 11 of the Act. Again, Mr. Garvey doesn't deal with this. He has one paragraph on page 19 of his heads of argument where he says in paragraph 61, it's evident that no claim of harassment can be sustained in the circumstances of the present matter, and this too appears to be common cause from the record. Nowhere is it common cause from the record. Absolutely nowhere is it common cause from the record. Whether the admitted conduct of publishing that comment constitutes or meets the definition of harassment is a matter of law. It's a matter for the court, even if it were somehow factually admitted one way or the other. But we submit that these references, and we'll explain in more detail in our reply to these belated heads of argument, why these references do not indicate at all that it's common cause that there was no harassment. Let's look then at what is meant by harassment under the law. Harassment in section 1.1 of the Act means unwanted conduct, which is persistent or serious. So it doesn't have to be persistent, it can simply be serious. And it demeans, humiliates, or creates a hostile or intimidating environment related to membership of a group identified by one or more of the prohibited grounds. Very clearly, it was unwanted by Chinese people. Very clearly, it was serious. To call for a group of people to be wiped out, eradicated, killed or murdered, according to the dictionary definition, is inherently serious. And of course, demeans, humiliates, and creates a hostile or intimidating environment for Chinese people in South Africa. Now, none of that is engaged with by the fourth respondent at all. There's simply what in effect is a bold and vague denial that the definition, which isn't even recounted in his heads of argument, Mr. Garvey's heads of argument, has not been met in one or more of those elements. So we submit that the case is unanswerable and unanswered in that respect. Then finally, unfair racial discrimination, section 7 of the Act. Now, Mr. Garvey misses the point completely again here, as he did throughout his questioning of the witnesses, where he says that discrimination is defined in section 1. He's referring to section 1. He doesn't do so explicitly, but I can tell you it is. This is paragraph 62 of his heads. Any act or omission, including a policy, law, rule, practice, condition, or situation which directly or indirectly imposes burdens, obligations, or disadvantage on, or withholds benefits, opportunities, or advantages from any person on one or more of the prohibited grounds. Now, firstly, ours is not a case of unfair discrimination on whatever ground, which would be section 6 of the Act. Ours has always been a case of a violation, a contravention of section 7 of the Act, which is unfair racial discrimination, which defines unfair racial discrimination more specifically than section 1. It says no person may unfairly discriminate against any person on the grounds of race, including the dissemination of any propaganda or idea which propounds the racial superiority or inferiority of any person, including incitement to or participation in any form of racial violence. So let's look at this definition then. Now, even if we were to use the section 1 definition, it's satisfied. You're clearly imposing disadvantages on Chinese people by saying they must be eradicated. In society, you are subjecting them to ill treatment on the basis of their race. That is imposing burdens and disadvantages on them. Now, using the appropriate, more specific definition, clearly writing words on Facebook, conveying meaning, saying that someone must be wiped out, is disseminating an idea. And that idea we submit, because them is referring to Chinese people, propounds their racial inferiority. Because they are Chinese, they deserve to be treated in this way. So racially, they are inferior, including incitement to any form of racial violence. And we submit this is clearly incitement to racial violence, to say that Chinese people must be wiped out. And so the only defense, just to recapitulate, against all three charges, all three claims, hate speech, harassment, and unfair discrimination, is them does not refer to Chinese people. That's the only issue in dispute between us and the fourth respondent. And we submit, for the reasons we've given exhaustively, that them could only have been referring to Chinese people. I'd like then to move to remedy, my lord. This is completely unanswered. We've made detailed submissions about what would be an appropriate remedy. We've given aggravating factors. Now, I'm going to take, my lord, to certain important aggravating factors that are not expounded upon at length in our heads of argument, but they're very critical. But no attempt has been made in Mr. Garvey's heads of argument to provide mitigating factors for remedy. You know, why should the fine? We've asked for a payment of damages to the Chinese old age home of 150,000 Rand because we believe this is as serious as the Penny Sparrow matter where that was awarded. It's in line with the trend. Even higher amounts have been awarded in, for example, the Vicky Momberg case. Now, the submissions we've made are bolstered in several respects. And this will tie in also with a question that you asked about a letter that was sent on behalf of the 4th and 8th respondent, where they said, you know, we were reacting in outrage to the treatment of donkeys. I'd like to address that because that's not a justification, that's an aggravation, in fact. My Lord, Mr. Pon, when questioned, spoke about insult to injury, that Mr. Horn, the 4th respondent's conduct in particular in the litigation had added insult to injury. And this is where aggravation of harm and aggravation of damages comes in. The first adding of salt to the wound appears in the pleadings bundle at page 75, if my Lord will turn that up.
Yes.
So this is an affidavit that was filed by Mr. Horn, where he was pleading over. So he had raised objections based on jurisdiction and I think some other technical ground which were dismissed. And then he pleaded over and said, you know, that I wasn't, you know, I was just talking about the gangs. And I was reacting to these, you know, to the killing of donkeys. But then on page 75, paragraph 23, he says something very important. He says, however, as a supporting Annexure E to my affidavit, I'm including an email from the founder owner of the Karoo Donkey Sanctuary, Jonathan Sherwin, who's a personal friend of mine, and who sent me a copy of the particular email in which he expands on the matter in some detail to the members of the Chinese Association, in which he too has humbly apologized for any negative publicity that his Facebook page might have caused to the Chinese community at large. I'd like to stop there. The words negative publicity are so euphemistic that they become downright insulting. To say that those violent words that I read out, those genocidal words that I read out of the comments on the Karoo Donkey Sanctuary page, not just Mr. Horn's, but the others as well, is negative publicity for the Chinese community, is frightfully insulting. It's to deny that this was demeaning and degrading and dehumanizing, to call it simply negative publicity. Now he goes on and says, although he highlights many supporting examples of the illegal and inhumane mass slaughtering of donkeys throughout the world, he has also included many internet links and personal videos pertaining to this pandemic here in South Africa. So let's go and look at this Annexure E then, which appears on page 91 of the same bundle. So this is the email from Mr. Sherwin, which Mr. Horn associates himself with and asks to be incorporated as part of his defense. He says, now this is the third paragraph, he says, given the global donkey pandemic in terms of the unprecedented, inhumane, and generally illegal mass slaughter of donkeys to supply the insatiable demand for their skins in China, I believe it's prudent to highlight the plight of the donkeys and, more importantly, our crusade in the South African context. Then he, in 2 paragraphs down, he has a bold heading called The Facts. Then he says, he refers to certain news articles which implicate Chinese people in this donkey trade. He says donkeys are being stolen from rural farmers, etc. Chinese nationals are under persecution. I think he means prosecution. Number 2, the Chinese who play Fafi here ask me if I can get them 40 donkeys. 3, donkey skins are leaving the country by the container load. Chinese forwarding company responsible for the documentation. Chinese nationals under investigation. Then he says, number 4, I'm in possession of a video shot personally in 2016 of a Chinese gentleman in Polokwane confessing to the trade of 20,000 donkey skins. 5, I'm in possession of several videos shot personally on 27 October 2016 of rural chiefs talking about Ama China, stealing and slaughtering their donkeys. Number 7, the value of donkey in China is such and such. Clear money laundering. Then he says in the third paragraph from the bottom, he goes on to say, I've personally taken on the plight of the donkeys as they needed a credible voice. While it is by no means my intention to vilify the Chinese as a nation, regrettably, the facts are the facts where the shockingly cruel trade in donkeys is concerned. And then in his final paragraph, he says, with regards to the current hate speech suit against certain members of the public for their culturally defamatory comments about the Chinese, with respect, the heat ensued in the weeks following my rescue of 300 donkeys from the infamous Hartswater auction, where all would have gone to slaughter for their skins. So there, my comment here is the phrase culturally defamatory comments about the Chinese. So he's saying that the comments were about the Chinese and were about their culture, not about the perpetrators or anything like that, about the Chinese and their culture. Then on the next page, he says, I'm not by any means condoning any of the negative comments made on our Facebook platform, but I'm requesting, and he says, he concedes, they were totally unacceptable and clearly tantamount to hate speech. And one of those that he deleted was Mr. Horn's. That's on record. It's common cause. So even Mr. Sherwin believes it was hate speech. But what I am requesting, given the content of my email, is that a formal written apology to the association from each individual should suffice. For your information and interest, I'm attaching screenshots of the Google search content images that features at the top of a basic search on the donkey skins trade. So this is Mr. Horn's first version that he puts before the court. He takes it upon himself to lecture Chinese people about animal cruelty. He does a number of things in this respect. He firstly assumes, despite their press release saying, and their complaint to the Karoo Donkey Sanctuary saying, animal cruelty is not a part of the character or culture of Chinese people. We, who are Chinese, happen to find this abhorrent and we have nothing to do with it. But then he comes back in his response and says, oh, yes, sorry about the culturally defamatory remarks. Sorry about the remarks about your culture. Sorry for the bad publicity. Regrettably, the facts are the facts, and he sets out 7 bullet points about all the evidence he has about why it is right to blame the Chinese. It's the equivalent now of, firstly, that is a gross extrapolation to say that because some people somewhere in China might be consuming illicit animal parts, that this is something that is inherent or intrinsic to Chinese people as a race. That is to say that because French people torture baby cows to make veal, and torture baby chickens to make foie gras, because Norwegian people club seals and puffins in the most cruel and reprehensible manner that animal rights groups are up in arms about. To say to me that white people are clubbing seals and puffins, all white people, the facts are the facts. You whites are responsible for the cruelty against animals. Now that's exactly what hate speech is about. It's about generalizations and stereotypes. It's applying to a race some misconceived stereotype about a particular segment of a community. You attribute to all people of Chinese race something that you believe is characteristic of one part of that community, unjustifiably so. It's to say, for example, as we know, the practice of ukutwala in Zulu culture has been described by some groups as, in fact, a form of customary law rape and kidnapping. Now it's to say that all Zulu people are rapists. I mean, it's a horrendous stereotyping, and it's false, and it's not simply culturally defamatory. It is hateful. and it is harmful, and it's prohibited by the Act. I'd like to go then to the second act of aggravation. This is where Mr. Pon is being cross-examined by Mr. Barrense. And this was a tortuous experience for everyone involved, as my Lord will recall. If we turn to the transcript bundle at page 1129,
Yes. I'm there. I've got
sorry,
it.
I'm just pulling up the page myself. So Mr. Barrense had already been reprimanded by my Lord for making speeches to Mr. Pon, and was asked after a most deplorable exchange in which Mr. Barrense addressed my Lord as though he was addressing a servant. And I myself had to stand up twice as an officer of the court to bring him into line, as did Mr. Ismail. It was without a doubt the most reprehensible display of disrespect I've seen in a courtroom, any courtroom. And we'll deal with that when we come to costs, when Mr. Ismail comes to costs. But this is the backdrop here. Mr. Barrense has just been warned to ask relevant questions about his own client's comment and whether it constitutes hate speech. Mr. Barrense then at line 7 starts saying, to Mr. Pon, are you aware that the traditional Chinese medicine market is the world's oldest healthcare tradition? Mr. Pon says, I know it was old, I didn't know it was the oldest. Mr. Barrense says, yes, well, it's claimed to be, yes. It has been reported, are you aware that it has been reported that that particular medicine market or the medical market is helping drive some animals to the brink of extinction? I've heard that, I've not investigated it. But yes, but have you heard it? Then he goes on about the TCM market. There was, as this part of Mr. Barrense's cross-examination is replete with intervene and speaking simultaneously, as my Lord will know. But let's move to the next page. And he says, I'm just trying to get to the next question. Are you aware that the market to the Chinese, traditional Chinese market products, medical products, had a devastating consequence for many species of wildlife, which you answered, you said you are aware. Then I had a debate with Mr. Barrense about whether in fact he had said he was aware. The point here is that Mr. Barrense in the cross-examination on the instructions of Mr. Horn decides that as part of his defense, he is again going to lecture Chinese people about how terrible the Chinese consumption of animal products is. It's driving animals to extinction, and it has a devastating consequence for many species of wildlife. So it's adding insult to injury again. It's saying the facts are the facts. You Chinese are responsible. I mean, how is Mr. Pon supposed to argue to any more than I'm supposed to argue to seal clubbing in Norway? Now, the next instance of insult to injury is further in this very lengthy cross-examination, which eventually took about 5 hours over 2 days. If we turn to page 1142,
Yes.
Now, this is where Mr. Barrense said he was, let me go to the bottom. He took a while to get to the point, but at line 24 of this page, he says, there are far greater human and animal rights violations that need to be addressed in this country. And versus your matter on the next page, would you say it is a matter of perspective? That is all I'm saying. I'm not demeaning your case by any manner or means, but when one looks at the bigger picture, I'm asking you, could it well be that in fact, in a matter, the manner of perspective, we are dealing here with a minor issue? And you'll recall, my Lord, that Mr. Pon took great exception to this. And Mr. Barrense repeated several times over the next 2 pages that this is a small issue. It's a minor issue in perspective. And I won't go into the detail. You know, Mr. Pon explicitly says on page 1144 at line 10, he says, this is our turn to be, our voices to be heard. I'm sorry. For someone, now this is the problem, and this is where it is insult to injury. It's where someone thinks that it doesn't matter, thinks that our lives do not matter. Now, so this is the third instance of heaping salt on the wound, where he is diminishing the experience of being told that they must be wiped out, diminishing not only Mr. Pon's, but all other Chinese South Africans' experience of being told that they, their mothers, their fathers, and their children must be wiped out. It's a small issue, it's a minor issue. With respect, my lord, it's not a minor issue. And it's reprehensible for this questioning to have been put in the Equality Court of all places. Now, the final insult to injury that I'll refer to is later on in the same questioning. It's page 1155. Now, Mr. Baransa again is trying to, well, tries to sermonize through a series of questions, and he had to be stopped by my lord eventually. But he says on page 1155 at line 6, thank you. Do you believe in the rule of law, Mr. Pon? I do. Do you believe in upholding it, Mr. Pon, even if you disagree with it? Believe in what, etc. Do you believe in upholding the rule of law, even if you disagree with it? Yes. Do you have relatives living in China? Mr. Pon says very, very distant, not that I know of. I have not kept in contact with any of them. Mr. Baransa says, I seem to recall that you testified that you've been to China, I think 60 or 70 times. I think that's meant to say 16 or 17. In any event, Mr. Pon says, yes. Well traveled, says Mr. Baransa. So are you aware of the basic human rights violations and atrocities that are a constant part of everyday life in that country against your very own people? And then on the next page, my lord, with respect, rightly asked Mr. Baransa, when are we going to get to your client's version, the reason why we are here, and stopped this ridiculous line of questioning, an insulting line of questioning, to say that because Mr. Pon is ethnically Chinese, he must answer and be accountable and responsible and answerable for human rights abuses in China. Mr. Baransa is putting it to Mr. Pon that Chinese people are not only animal rights abusers, but human rights abusers. As a race, it heaps mountains of salt on the wound, irreparably, my lord. So it's for those reasons that we submit that a substantial award of damages, as well as a substantial period of tolerance training, is appropriate, as well as an apology in this case, a public apology. My lord, we've quoted from SARS, the South African Revenue Services versus Commission for Conciliation, Mediation and Arbitration and Others, which is a constitutional court judgment by the former Chief Justice Makume, unanimous, where it was 2017, Volume 1, SA 549 CC at paragraph 14, where the Chief Justice said, racist conduct requires a very firm and unapologetic response from the courts, particularly the highest courts. Courts cannot therefore afford to shirk their constitutional obligation or spurn the opportunities they have to contribute meaningfully towards the eradication of racism and its tendencies. And it's for precisely this kind of purpose that the Equality Court was set up, and why it's provided with a wide range of powers, including the payment of damages in respect of the impairment of dignity, pain and suffering, or emotional and psychological suffering. We've referred to the Sparrow case. We submit it's equally, if not more egregious, given its violent character. And we've given our submission as to why the comments are especially serious on their own, why they have been aggravated on no fewer than 4 occasions, during the conduct of the litigation. And therefore we move for an order in terms of paragraph 155 and the subparagraphs of our heads of argument. Now, again, where we refer to within 6 months, the false respondent shall pay 150,000 Rand, and within 30 days an unconditional apology. Again, we mean within such days from the date of judgment. And we submit that the false respondent should be ordered to pay the complainant's legal costs. The scale of costs will be addressed by Mr. Ismail after Ms. Hardy has addressed the court. My Lord, do you have any questions for me about the case against the false respondent?
No, not really. I think you responded. I wanted to ask you about on section on harassment itself, but I think you've answered it that section 1.1 provides that the harassment is not only persistent but must serious. In other words, I thought that it was persistent and serious, but it is either or. So
yes.
I think.
And if my Lord would like authority of cases where it was held that once-off expressions of speech constituted harassment, I can provide some. The one off the top of my head is Sonke Gender Justice Network versus Malema.
Okay.
Let me give you the citation just for the sake of completeness. And there are many others, but this is certainly one of them.
All right, I'll check it. All right. Yes, thank you.
Okay, let me give you the citation while I'm still on screen. It's 2010, volume 7, BCLR 729
Yes.
EQC.
Okay. Thank you.
My Lord, thank you for your time. I note that it's after 1. I don't know whether you'd like us to continue or whether you'd like to break for lunch before Ms. Hardy addresses the court.
Look, I'm easy. I'm not sure how long Ms. Williams is going to take. If she's going to take more than an hour or 30 minutes, then we should rather break now. I'm just trying to check. We have to finish today.
Indeed, my Lord.
We have to finish today. So I'm not sure how long Ms. Williams is going to be. Is it Ms. Williams or is it Kathleen who's going to address me?
It's Ms. Hardy.
Oh, okay.
My Lord, I will take 10 minutes at the most, 15 minutes in my submissions.
So you're dealing with the issue of the confessors now?
The confessors and the defaulters, that's correct, my Lord.
Yeah. We will, oh, sorry. Okay, I'm running low. So sorry. Sorry about that. I was not aware that I plugged out. I will then allow Ms. Hardy to then address me, and then we can then take a break, come back at 2 o'clock to give an opportunity to Advocate Garvey to then respond. Advocate,
as you, my Lord.
Okay.
Thank you, my Lord. My Lord, the complainant's heads of argument set out in detail the position concerning the remaining respondents, referred to as the confessors and defaulters. I do not intend repeating those submissions. I will provide an overview of each of the remaining respondents. I will begin with the defaulters. I will then make submissions concerning the confessors, and I will conclude with the position concerning the 12th respondent. My Lord, before I begin with the defaulters, no order is sought against the 3rd respondent. My learned friend, Mr. Ismail, indicated that there was no service on the 3rd respondent and that she never participated in these proceedings. So to begin with the defaulters, 4 respondents fall within this category. 3 of those respondents were properly served and did not enter an intention to oppose. They have never participated in these proceedings, and these are the first respondent, Alice Henning, the second respondent, Anya Locke, and the 6th respondent, Joy Temoeshazen. The 7th respondent also did not file an intention to oppose, but did file an affidavit in terms of Rule 31. The 7th respondent, Lana Berger, in that affidavit indicates that she places herself in the hands of the court in terms of judgment. My lord, that affidavit contains what we consider to be an attempt at an apology by the 7th respondent. And she also puts forward certain personal facts which she would like the court to consider. When properly considered, my lord, we submit that the apology is not an unconditional apology. It does not admit that Ms. Berger's comments constitute hate speech, unfair discrimination, and harassment. And for these and other reasons, my lord, we submit that it is not acceptable. It is not an acceptable apology. The concerns in relation to this apology, my lord, are detailed at paragraph 271 of our heads of argument at page 105. We submit, my lord, that the words of the 1st, the 2nd, the 6th, and the 7th respondents constitute unfair racial discrimination, hate speech, and harassment against the Chinese community in South Africa, in contravention of Section 7, 10, and 11 of the Equality Act. And on this basis, my lord, we further submit that these defaulters should be ordered to pay damages in an amount of 70,000 to 100,000 Rand to a charity nominated by the complainant, the Hong Ning Chinese Aged Home. The 1st, the 2nd, and the 6th respondent, my lord, have never dignified these proceedings with their presence, and we submit that in the circumstances, 100,000 Rand is an appropriate amount. With respect to the 7th respondent, yes, my lord?
You said the 7th respondent is 70 to 100,000.
So no, my lord. So the 1st, the 2nd, and the 6th respondents, my lord, we submit an appropriate amount is 100,000 Rand. And so with respect,
you mean all four, all 1st, 2nd, 6th, and 7th?
No, my lord, the 1st, the 2nd, and the 6th for 100,000 Rand. The 7th, my lord, we propose an amount of 70,000 Rand as being appropriate. And the reason, my lord, is because the 7th respondent did make some effort to participate in the proceedings. She tendered an apology, albeit a flawed apology, and she placed certain distressing personal circumstances before the court in mitigation. So for the 7th respondent, my lord, we submit 70,000 Rand is appropriate.
Thank you. Yes.
It is possible, my lord, as well, that one or more of the defaulters may be unable to pay some or all of these damages. And so, my lord, at paragraph 286 of our heads of argument, we propose that the court's order should allow these defaulters to approach the court within 30 court days to account for his or her financial situation and to seek a commensurate substitution of some or all of the damages with the equivalent amount of community service. In addition,
in the alternative.
Yes, my lord. Yes, my lord, in the alternative. In addition to the damages, the complainant seeks an order against the 1st, 2nd, 6th, and 7th respondents. And this we detail, my lord, at paragraph 287 of our heads of argument on pages 109 to 110, which is in line with the orders as agreed to with the confessors. My lord, this has to do with the apologies and the human rights sensitization training. So that is in addition to the damages.
Okay.
I will now turn to the confessors. 5 respondents fall within the category of confessors. 4 of the 5 respondents, my lord, the 5th respondent, Dawn Reeve, the 9th respondent, Regina Richardson, the 10th respondent, Brian van der Walt, and the 11th respondent, Shannon, they all filed Rule 31 confessions on which the complainant seeks judgment. These respondents admit that their comments constitute unfair racial discrimination, hate speech, and harassment against the Chinese community in contravention of the Act. And they consent to a final order on the terms agreed with the complainant. My lord, the detail of these terms for each of these respondents appear at pages 77 to 91, which is paragraphs 213 to 246 of our heads of argument. The 12th respondent also filed a Rule 31 confession. However, it was done on terms that the parties are unable to reach an agreement. While the 12th respondent admits that her comment constitutes race-based hate speech, unfair discrimination, and harassment, there are 4 aspects that the parties have been unable to reach agreement. First, my lord, is that the parties are unable to agree on the number of hours that the 12th respondent would be required to undertake community service. The 12th respondent proposes a total of 50 hours.
How many?
50, my lord, 50 hours.
Oh, yeah.
Whilst the complainant proposes 500 hours, as is the case with all other confessors. The second issue, my lord, is the costs contribution payable by the 12th respondent. The 12th respondent proposes a contribution of 100,000 Rand, inclusive of the costs order that was granted against her for the point in limine that she raised in March 2019. That point in limine was dismissed with costs. The complainant, my lord, is of the view that the 12th respondent should pay a cost contribution of 100,000 Rand in addition to the costs order for the dismissed point in limine. So the first issue, my lord, is the number of community service hours. The second is the cost contribution. The third issue, my lord, is that we submit that the 12th respondent's apology should be amended to include reference to race at paragraph 5 and 6 of that apology. My lord, this is dealt with in some detail at paragraphs 243 and 244 of our heads of argument, where we indicate where the references to race should be inserted.
Okay.
Finally, my lord, we submit that the apology should be pinned on the 12th respondent's Facebook timeline as a top post that must be visible to the public for a period of 6 months. And it similarly will be placed on the complainant's website for the same period of time. That is, as the other confessors have agreed to, that the exact same agreement. My lord, for your purposes, the detailed background to the discussions between the 12th respondent and the complainant's legal representatives can be found, my lord, in the record on the 3rd of December 2019, and it appears from page 1435 to page 1451.
Yeah.
It is also detailed at pages 91 to 97 of our heads of argument. So, my lord, the position is that the complainant and the 12th respondent leave these 4 issues in the hands of the court to make an appropriate order in the circumstances.
Yes.
Does your lordship have any questions in relation to any of these respondents?
No, what I would then prefer as because there's quite a lot of material to read, is that you should forward to me your draft orders in respect of each of the confessors and the defaulters. Yeah,
My lord,
that is most helpful when you finally, so that I don't mix up things. Then I can choose which one. Your draft orders will be very helpful. Okay.
My lord, we will undertake to provide those draft orders to you when we provide our replying submissions.
Yes. Thank you.
Thank you, my lord.
That is all I need. Yes.
Thank you, my lord. Those are my submissions.
Thank you, Ms. Hardy. Advocate Ismail, I had indicated that we should break for lunch if people so wish. I know that you wanted to address me on costs, but I wanted to give time to Advocate Garvey to then respond thereafter. Do you think you will be more than 30 minutes?
I shouldn't be more than 20 minutes, Makume. Can I propose, subject to your leave, the following? I address you on the question of costs and conclude the submissions on behalf of the complainant. Then we could break for a truncated lunch period, if that is agreeable to you, and then resume thereafter.
Okay, that'll be fine. Can proceed with costs.
As the court pleases.
Okay.
Justice Makume, the question of costs have been addressed very fully in our heads of argument from paragraph 288 onward. That is in our heads from page 114 onward. I'm going to highlight some of the important points because I believe they warrant a response. I'd like Mr. Garvey, on behalf of the 4th and 8th respondents, to receive the full benefit not only of our written submissions, which he's considered, but also our oral submissions in that regard, because he hasn't really addressed any of these questions. Insofar as costs are concerned, we point out the general applicable principles prevailing under the Equality Court and the Act, section 21, subsection 2, paragraph O, provides that an equality court may, after holding an inquiry, make an appropriate order of costs against any party to the proceedings. Regulation 12.2 of the Act provides that each party bears his or her own costs unless the presiding officer directs otherwise. And the Equality Court exercises its discretion as to costs in all the circumstances of the case. The ordinary rule, as is trite law, is that the successful party is awarded costs on the scale as between party and party. The court has the wide discretion to determine costs exercised judicially with due regard to all the relevant circumstances. Attorney and client costs, i.e. costs on a higher scale, have been awarded where litigants' conduct has been found to be vexatious and an abuse of the court process, or even in the absence of an intention to be vexatious, where the conduct has proven to be unreasonable. In short, the absence of bona fides may warrant a costs order on a higher scale, or even where the party acted unreasonably. Now, what happened in these proceedings, Justice Makume? In these proceedings, it is clear that the Equality Court was supposed to ensure that the complainant, as the victim, was able to obtain expeditious relief and a ventilation of its complaint in the court. It's a victim, or its representatives are victims of past and present discrimination. They are trying to reinforce or establish their dignity and affirm their equality. The expeditious nature of proceedings, which is underpinned by the very purpose of the Act, has been completely undermined by the obstructive and contemptuous approach adopted by the 4th and 8th respondents, and unfortunately, I have to add, their legal representatives. Now, the bottom line is, cost orders were already made in this matter regarding the 4th respondent's failed special plea, the 8th respondent's failed application to strike out, the 8th respondent's failed attempt to postpone the inquiry, the 8th respondent's failed attempt to admit late expert evidence, the 8th respondent's failed application for recusal, and the 12th respondent's failed point in limine. Those costs all stand. They relate to discrete portions of the hearing. What is really at issue right now, Justice Makume, is the balance of costs, the remainder of the costs of these proceedings. We submit in that regard that these costs must be borne by the 4th and 8th respondents jointly and severally, the one paying, the other to be absolved, on an attorney and client scale, i.e. the highest scale. And why do we say that? Well, their conduct. Let's deal with that first. We start out with the 4th and 8th respondents' initial stance in this complaint. Both of them were at the time represented by Nolte Inc. Those were their attorneys. The position they adopted at the outset was that there was need only for a roundtable meeting to discuss their quote unquote outrage against the slaughtering of donkeys, etc., and nothing more. So they're accused or told, look, you are, peddling hate speech here. Their response is, we're only prepared to talk to you about our outrage about donkeys, nothing else. This attitude heaped insult onto the Chinese community's injury. It did so by suggesting that the 4th and 8th respondents' comments had been justified because of the harm that had been caused to donkeys, as Mr. Winks illustrated to you. It has nothing whatsoever to do with hate speech. Any harm caused to donkeys can never justify hate speech against the Chinese community. It simply doesn't equate. And that is the approach they adopted right at the outset. They were dismissive of the seriousness of the complaint by claiming that they uttered merely an emotional response. At every turn, their conduct has been obstructive and antithetical to the purposes underpinning the Equality Act. And we demonstrate that in the heads. We start out with the 4th respondent's technical, evasive, and contradictory defenses at page 119, paragraph 308. The 4th respondent flip-flopped. Firstly, he filed a special plea and an exception challenging this court's jurisdiction to hear the complaint. Both those failed. The 4th respondent also answered the complaint in an affidavit. In that affidavit, he admitted making the comment complained of, but he defended it on the basis that it wasn't his intention to vilify, embarrass, or incite racial hatred towards the Chinese community, and it was simply an instant reaction to the carte blanche program. Then the 4th respondent changed his defense. Suddenly, he denied he'd made the comment at all. Thereafter, the 4th respondent changed his defense yet again. In the middle part of the first inquiry, he included further documents in the trial bundle, which disclosed that he had in fact made the comment on the Karoo Donkey Sanctuary Facebook page. And he argued that, properly interpreted, his comment was referring not to Chinese people, but to so-called gangs responsible for killing the donkeys. So what he has demonstrated in his conduct is that he starts out with a technical jurisdictional objection saying this court can't hear the matter. He loses that, and then he denies he's made the comment. Then he admits he's made the comment. He's playing games, Justice Makume. He's running any defense that he could. It is not only the hallmark of a desperate litigant who does that, but in this case, in this context, where a community is saying, look, you've injured us, you are invoking racial groups and stereotypes, you are calling for the wiping out of our people, a race of people. It is unacceptable. What does he do? He plays games. That heaps insult upon injury. To use the analogy of Mr. Winks earlier, it is pouring salt on the wound. Then we deal with the fourth respondent's inappropriate conduct in the courtroom. He was represented by 4 different people during these proceedings. And here I'm at page 129, paragraph 329 of our heads. Justice Makume, the submissions I'm making to you are being made in a fairly hurried state. The underlying detail underpinning each submission is in the footnotes and in the detail of the submission we make. And if you have regard to that, you will see that each of the submissions we make are carefully supported with reference to documents and the transcript. As I was saying, the fourth respondent's inappropriate conduct continued in the courtroom. He was represented by 4 different persons in these proceedings. Their conduct, in turn, attributed to him was nothing less than scandalous. We cite a few examples. The fourth respondent took unjustifiable umbrage at the evidence of Mr. Wing had testified as follows. He said, "It was only ever white people who treated us as inferior and made us feel unsafe and unwelcome. From as early as I can remember, I became extremely tense and anxious whenever I had to encounter white people." This is the Mr. Wing who gave evidence to the effect that he was evicted from Vitas and who suffered numerous indignities growing up in apartheid South Africa at the hands of white South Africans. The court then asked Mr. Wing some questions about the statement I've just read to you, Justice Makume. Mr. Barnes, acting for the fourth respondent at the time, interrupted Mr. Wing as he was giving his testimony, and he stood up to make a point. The court asked Mr. Barnes to sit down and inquired if he was raising an objection. Mr. Barnes did not raise an objection. He instead confronted the presiding officer in a belligerent manner. He asked why the court was asking Mr. Wing about white people, implying that it was inappropriate to be asking questions about white people. The court reprimanded the fourth respondent and reminded Mr. Barnes that the presiding officer is not here to answer questions. That's what your lordship indicated him. A further instance, during the fourth respondent's cross-examination of Mr. Pon, the fourth respondent, through his representative, was sarcastic with the presiding officer. By the time the fourth respondent began with his cross-examination, Mr. Pon had been on the stand for 3 days already. The court had just granted the eighth respondent an indulgence to consider her position after the ruling on Mr. Judon's affidavit. And in order to utilize the available time, the court then directed the fourth respondent to begin with his cross-examination of Mr. Pon, so as not to waste time. Mr. Barnes, the representative of the fourth respondent at the time, requested that he be excused, but the presiding officer pressed him to begin with his cross-examination. Instead of starting or politely indicating his predicament, the fourth respondent's representative replied, "Well, I'm not going to stand here and pee in my pants." The tone in which he said that, the manner in which he said it, and the words he employed to say it, at the time demonstrated once more severe disrespect and contempt for the court and this process. Mr. Barnes then, having taken his comfort break, went on to read verbose memorandums to Mr. Pon and to ask Mr. Pon numerous irrelevant questions. The court attempted to direct the fourth respondent to stop reading memorandums. The court attempted to suggest that he ask relevant questions, but the court was met with severe resistance. Mr. Barnes, on numerous occasions, accused the presiding officer of railroading him. And over at least 2 days, Mr. Barnes spoke loudly over the presiding officer on numerous occasions. His behavior was nothing less than contemptuous. The court, in fact, had to warn him that he was being contemptuous. The complainant's counsel was even compelled to explain to Mr. Barnes how to behave before a court of law. The fourth respondent's further incident is the following, or further series in the long line of incidents is the following. The fourth respondent's line of questioning Mr. Pon revealed that the fourth respondent, regardless of his status, of his stated defense, had complete contempt for for Chinese people in South Africa. And Mr. Winks has already addressed you on this, where he described the experience by Chinese people as a small thing. He belittled it. Then we deal with the 8th respondent, Justice Makume, and this commences at paragraph 313. The 8th respondent adopted technical and evasive defenses. She first admitted publication of the impugned comment in her attorney's letters. Then she came up with a defense, which was a bald and general denial that she made the comment on the carte blanche Facebook page on the particular date and time. She said, effectively, prove it. We also have a number of procedural impediments contrived by the 8th respondent. And here I'm dealing with the heads from paragraph 316 onward, Justice Makume. The 8th respondent purposefully, i.e. intentionally, did everything in her power to delay the inquiry or prevent it from running efficiently or at all. Now, Justice Makume, we don't lightly make that submission in writing or orally. We do so after having carefully tracked through the record, after having carefully looked at the documents, after having looked at the transcript and discussed it between ourselves as counsel and with Namford Inc. And only after a very considered debate have we made this submission. We say that she intentionally delayed the inquiry and prevented it from running efficiently by obstinately raising numerous procedural impediments that were invariably without merit. We cite a few examples. It started out at inception. The 8th respondent's approach became apparent at the first pre-trial conference held on 28 January 2019. She failed to file a Rule 37.4 notice before the pre-trial. She attended the pre-trial without a proposed agenda of her own. At the beginning of the pre-trial, she was asked by the complainant's representatives, or the 8th respondent's representatives was asked by the complainant's representatives if the 8th respondent had any proposals to curtail the issues between the parties, because obviously we want to have an expedited and efficient hearing. The 8th respondent had the audacity to suggest that the way to curtail issues was for the complainant to withdraw its complaint and tender costs. In short, she adopted a cynical and obstructive attitude. At that pre-trial conference, that cynical and obstructive attitude manifested even further. She took positions that were legally incorrect and highly technical. She, for example, refused to agree on the proposed dates regarding the finalization of the indices of the pleadings, notices, and trial bundles. She refused to agree on a standard way of managing documentary evidence, which allowed her to dispute any document on reasonable notice. This was irrational, even when the complainant put to the 8th respondent that it didn't understand why she wouldn't agree to any reasonable proposal that was of no prejudice to her whatsoever, but which facilitated the dispute being resolved according to an agreed mechanism. The 8th respondent refused to explain her position. After the pre-trial conference, the 8th respondent continued with that obstructionist approach. Just before the eve on the dates on which the inquiry was set to proceed, the 8th respondent issued a Rule 14 notice seeking, amongst other things, a copy of the complainant's constitution, despite, by this stage, the complainant already having discovered this document. I'm at paragraph 319. The complainant on the eve of the hearing, the 8th respondent on the eve of the hearing also issued a Rule 47 notice seeking R1 million in security for costs. The 8th respondent also used the Rule 14 notice to seek to personally intimidate the complainant's office bearers, the chairperson Erwin Pond, the vice chair Francis Lai-Hong, as well as its attorney of record, Joyce Namford. The Rule 14 notice threatened to hold them personally liable for any costs order that may be made against the complainant. The 8th respondent never followed up on its Rule 47 notice with any application for security for costs. It was clearly nothing more than intimidation and obstruction. A further incident, during the second day of the third directions hearing, this being a day that should have been used during the for hearing of the inquiry, the 8th respondent insisted on arguing for a full day through her representatives without seeking any particular relief. That's astonishing, Justice Makume. The 8th respondent simply incorrectly submitted for the whole day that the matter was not ready to proceed, despite the complainant indicating it was ready to proceed. Justice Makume, once more, this harks back to the purpose of the Act and the procedural framework to ensure that the complainant, the aggrieved, victimized party, is given an opportunity to ventilate its story. What we have here was a classic example of a filibuster. That day that was taken, seeking no relief other than to tell the court that this matter is not ready to proceed. When the inquiry finally began on 27 March, the 8th respondent refused to say whether she consented to the evidence in chief of Mr. Henry Wing and Ms. Melanie Yap being adduced by affidavit. Now, this refusal was an abuse. The 8th respondent only consented to the use of the affidavit 8 months later, several days into the inquiry, when the third stage of the inquiry began in November 2019. Once more, undermining an efficient, expeditious resolution of the dispute, and doing so in a blatantly obstructive manner. The 8th respondent adopted a similarly abusive stance in the respect of the affidavit of Professor Yoon Young Park. The complainant wrote to the 8th respondent on 14 November 2019, attaching Professor Park's affidavit and requesting confirmation whether the 8th respondent consented to the affidavit being adduced by the evidence of Professor Park's being adduced by affidavit, and B, intending whether the 8th respondent intended to cross-examine Professor Park's on any aspect of it. The reason for the request was obvious. We wanted to ensure the smooth, swift running of the inquiry. We wanted to avoid the considerable cost of flying Professor Park to South Africa from the United States. This request, like so many others, was simply ignored by the 8th respondent. As a result, the complainant had to fly Professor Park all the way from the United States to answer a few questions, which were actually meaningless questions posed by the 8th respondent. They had nothing to do with her evidence at all. Again, that is nothing less than malicious and obstructive. That is heaping insult upon injury. The 8th respondent's counsel prolonged Ms. Sadler's evidence unnecessarily. That's evident from the transcript. During the first part of the inquiry, the complainant tendered Ms. Sadler's old iPhone, which contained the original screenshot in her possession and on which she was giving in testimony. This was tendered to the 8th respondent. For 2 full days, the 8th respondent refused to inspect the old iPhone, despite repeatedly calling for that original data message on which Ms. Sadler relied. Then, during the third part of the inquiry, the 8th respondent attempted to mislead the court, suggesting that it had not been provided with the old iPhone containing the screenshots. At the beginning of the second inquiry, another incident at 326, paragraph 326, at the beginning of the second part of the inquiry, when the 8th respondent was supposed to continue her cross-examination of Ms. Sadler, instead, the 8th respondent started by arguing that the 3 counsel representing the complainant could not continue to do so as they were not on the roll of registered legal practitioners. So this was an objection raised on that morning without any notice. For the record, all of the counsel had been duly admitted and enrolled. But this was clearly yet another blatant attempt to distract and waste time, delaying the progress of the inquiry and undermining the very purpose of the Act. The eighth respondent, final incident I'm going to deal with on this point, the eighth respondent also filed their 36(9)A and B notice purporting to attach an expert notice or an expert affidavit on Mr. Jason Jordan. That was done in the middle of the inquiry, 7 or 8 months into the inquiry, 4 days before the commencement of the third and final part of the inquiry, and 6 days into the inquiry. And the argument regarding that issue took at least a day and a half, it took at least half a day. It was yet another abuse. And here's a critical abuse, Justice Makume. After the eighth respondent's attempt to introduce Mr. Jordan's affidavit through her cross-examination was rejected, she then immediately thereafter brought an application for recusal of the presiding officer. But this application was brought in bad faith. It made it plain that she didn't really believe the presiding officer was biased against her or that he couldn't fairly preside over the inquiry. And the reason why that's clear is that the eighth respondent said that if the presiding officer reconsiders his ruling regarding the preclusion of Mr. Jordan's proposed expert evidence, the presiding officer could continue to deal with the inquiry. So as long as you, judge, give me the outcome I want, I won't claim that you're biased. Now, with respect, that is a tactical recusal application. It is nothing less than an abuse. The fact that it was countenanced by her legal representatives is remarkable as well. It demonstrates once more her continued behavior of bad faith. And finally, the eighth respondent's inappropriate conduct in the courtroom. Mr. Garvey, on behalf of the eighth respondent, engaged in unconscionable conduct, including in relation to his cross-examination of Mr. Pon. He kept Mr. Pon on the stand for longer than necessary in the circumstances in order to exhaust him. Now, again, we don't say that lightly. Why do we say that? The eighth respondent's counsel cross-examined Mr. Pon for approximately 7 days. It is clear that Mr. Pon was cross-examined for longer than necessary because of the number of times the eighth respondent required in him to traverse exactly the same evidence with no apparent purpose. So he did that on multiple occasions, asking the same questions on the same issues, sometimes 8, 9, 10, 11 times. Mr. Pon was also cross-examined for longer than necessary. We say that because of the intentional approach adopted by the eighth respondent. This was exposed, and I'm at paragraph 340. This was exposed on Wednesday, 3 December 2019, the 6th day that Mr. Pon was under cross-examination. Mr. Pon overheard the eighth respondent's legal team say, "Let's keep him here another day." This statement was made by the eighth respondent's instructing attorney, Mr. Krause, to the eighth respondent's counsel, Mr. Garvey. Again, it indicates the bad faith where they deliberately sought to abuse the process in order to heap insult on injury. Mr. Garvey bullied Mr. Pon, treated him disdainfully. That conduct is attributable to the eighth respondent. The transcripts reflect that. On Thursday, the 4th of December, the eighth respondent's counsel was shouting at Mr. Pon. The transcripts reflect that. The eighth respondent's belligerent, obstructive, and aggressive conduct was clearly planned as a strategy from inception. It manifested from her very first engagement with the complainant. It continued throughout these proceedings. It was starkly exhibited through the conduct of her legal representatives. It undermined the Equality Court proceedings and the purpose of the Act. During the cross-examination of Mr. Pon, I'm at 343, Justice Makume, the eighth respondent's counsel asked Mr. Pon if he spoke English. This was a reprehensible racist insult because during his examination in chief, Mr. Pon articulately testified for hours in perfect, fluent English, and he had explained that he's a fourth-generation South African. In the circumstances, to question Mr. Pon's competence in English purely because he's ethnically Chinese while knowing that he's nationally South African and has given evidence as a professional in English, is a deeply and fundamentally racist act. Then the 8th Respondents Council put the following question to Mr. Pon. Your complaint is that you want everyone to get along. You don't want people to say offensive things to each other. You want people only to say things that people like and sit around the fire and sing Kumbaya. Again, counsel for the complainant placed on record that the 8th Respondent's approach heaps insult onto injury and is nothing less than scandalous. Justice Makume, that is just a sample of the conduct of the 4th and 8th Respondents and their legal representatives in the course of these proceedings. We submit that on a conspectus of all of the evidence and the conduct of the 4th and 8th Respondents and their legal representatives, they should be ordered to pay the complainant's costs to the extent not already covered by costs orders on the higher attorney and client scale, jointly and severally. And in conclusion, in relation to the case against the respondents, we say that this case is about words, but it's more than that, it's about belonging. The Constitution promises that South Africa belongs to all who live in it, united in our diversity. The Chinese community of South Africa is asking this court to honor that historic and sacred promise. Chinese people belong in this country just as much as any other race or ethnicity. They deserve dignity, respect, and equal protection of the law. 4.5 years ago, Chinese South Africans were told by the respondents in most violent language that they don't belong here, that they are not welcome here, that they should be wiped out. It falls to this court, 4.5 years later, to use the powers entrusted to it by the Act to restore their dignity and to restore their sense of belonging. And Justice Makume, the significance of this case should not be underestimated. Mr. Pon gave in his evidence an appropriate implication of these volatile words being thrown around by racists and hate mongers. He said the following. He said, words start off small. More and more people join in. They create this big voice of hundreds and thousands of people now talking. And you just need one person to take it too far and say, you are right. Let's go and kill their children. You are right. Let's wipe them out. Let's get rid of them. You just need one of those people to do that. Now, those words are very powerful, and we respectfully submit that Mr. Pon was correct, and it falls to this court to ensure that doesn't transpire. That reference appears in the transcript at page 6, 8, 9, lines 7 to 13. Those then are the submissions on behalf of the complainant. Justice Makume, given the time we've taken, that we break merely for 20 minutes, whereupon Mr. Garvey can commence his submissions. Might I also, through you, Justice Makume, inquire from Mr. Garvey how long he intends being?
Let's not, let's give him the time that he needs. I don't want to get to that debate again. Let's adjourn. It's now 10 to 2. Let's come back at 20 past, so at 20 past 2. Give us about 30 minutes, and then we can allow Mr. Advocate Garvey to then address us in response.
As the court pleases. Thank you very much.
An adjournment until 2 o'clock, until 20 past 2. Thank you.
Thank you.
Court, please.
Hello, good afternoon. Is everybody back?
Court, please, my lord, I'm present.
Okay. Counsel for the complainants, are you there? Can you please confirm that you are there? Advocate Ismail, Advocate Wings. Advocate Hardy.
Yes, my lord, I'm present.
You're all here. All right. Okay. Your colleagues, other councils, are they there also? Okay.
I'm
Yes.
just confirming, my lord, if you just give me a second.
We're all present, Justice Makume.
Is everybody here now? Can we proceed? Can I ask?
We can proceed, Justice Makume.
Okay. Looks like everybody is there now. Advocate Garvey, you may proceed, sir.
As a court pleaser, my lord. Would perhaps to the surprise of Mr. Ismail, I don't intend to be very long. And your lordship indicated earlier that your lordship had read the 4th and 8th respondents' heads of argument.
Yes.
Just wish to draw a few aspects in those heads to your lordship's attention, which I submit would in any event dispose of this matter as submitted by Mr. Ismail, that early on in his address, he submitted that for them to succeed in their case, they needed to prove 3 things, and says more particularly in respect, firstly, in respect of the 8th respondent, but also applies to the 4th respondent. And as I understood him, he said the impugned words, they need to prove that the impugned words were published by the respondent, that the words were based on one of the prohibited grounds, and that the words could reasonably be construed to incite harm, and the provisions in section 10 of the Act in question. So if your lordship has regard to our heads of argument, and much criticism is leveled at me personally, as well as my clients and my instructing attorney. And one would wonder if it wasn't maybe better that the 8th respondent and 4th respondents didn't exercise, or rather chose not to exercise their rights to be legally represented. As your lordship would have noted from the papers, that any actions that were taken by the respondents that I represent, and from the point, and I just make a qualification, I only represented the 4th respondent right at the end of this matter, so we must just draw that distinction. But the actions that were taken by the respondents, and when I say respondents, I'm referring to the 8th and 4th respondents, were nothing that were not permitted by the rules of court or didn't find foundation in any legal principle. They were entitled to be represented. They were entitled to give their representatives instructions, and their representatives were entitled to act on those instructions insofar as they were legally permitted to do so. So to turn around and say that we have obfuscated, we have drawn out this inquiry is with respect not true, my lord. I also place on record, my lord, that there's clarity that there's no criticism at a later stage. I'm fully aware of the cost order that your lordship has made in this matter to date. I'm fully aware of your lordship's rulings in relation to the admissibility of privileged, what we contended were privileged communications. And I'm fully aware of your lordship's rulings as to the application for your lordship's recusal. I'm aware of your lordship's ruling as to the I just rephrase your lordship's ruling as to the evidence that the 8th respondent and 4th respondent wanted to lead by way of your Don in presenting their case to the court. I'm fully aware of your lordship's ruling as to the late discovery, which was not even one day, it's canvassed in our heads, and I'll take your lordship there, as to the late discovery of the alleged screenshots or photographs or screen grabs, whatever we wish to call them at this stage. But my lord, more importantly, and this cannot be placed in dispute, if your lordship has regard to paragraph 6 of the heads of argument, the objection to the evidence of Sadlier was raised when, at the correct time, when it should have been raised, and it was even submitted to your lordship that the approach sought to be adopted by the complainant's legal representatives was an incorrect approach. Notwithstanding that fact, your lordship will see from the record in the paragraph 6 of the heads of argument, the submission made there is that to remove any doubt as to the approach adopted by the complainant expressly stated that, but once again, my lord, I put it on record that the evidence is being tendered provisionally. This again, my lord, at a record of the 27th of March, I don't have a reference. We only received, I may just point out to your lordship, my attorney only received the paginated record, which starts at page 1 and goes up to 1,000 and something, I think 1,800 or odd. We only received that late yesterday. I only had sight of it this morning, shortly before the commencement of these proceedings, and obviously I couldn't cross-reference the references, but we referred, and it's also referred to like that in the complainant's heads, to the relevant date of the hearing, the page number and the line. So then your lordship will see there still in paragraph 6, on the 27th of March, the record of 27th of March at page 83, lines 24 to 25, where again it is expressly recorded by the complainant that the evidence is being led provisionally. Your lordship even raised an issue stating that Sadler was not an expert on these devices, which he conceded. And then we submit that further, and I don't want to read each and every line, that your lordship would see from the record that the complainants then said, well, they will seek the provisional admission. They will then prove these screenshots by way of section 15.3 of the Electronic Communications Act. And my lord, we'll see further in that regard that we rely, or that the respondents rely on the authority in Glovu, my lord, at paragraph 47 of the heads. And this was acutely brought to the attention of the complainants. So we submitted it as wrong for them to say that it's technical. We tried to pull a technical move on them, for the lack of a better word. It was acutely brought to the attention prior that the approach adopted, where they seek the provisional admission of hearsay, and it was admitted by the complainant that that evidence was hearsay. As hearsay, it is inadmissible. They had to seek a ruling. They say, but we should have sought a ruling. The onus was not on us, my lord, on the respondents. And we deal with that aspect of the onus as well. The onus was on the complainant to prove its case. So the submission then, in short, my lord, is that they needed to prove on a balance of probabilities that the publication or the comment, it's actually just a comment, was in fact made by the 8th respondent. They failed to seek a ruling from your lordship on the admissibility of the inadmissible evidence, on their own version, conceding that it was hearsay and at that stage inadmissible. The 8th respondent could not then be expected to settle a case that doesn't exist. In this regard, draw your lordship's attention, and it was already drawn to your lordship, to the provisions of the Law of Evidence Amendment Act, section 3 sub 3 thereof, where it provides, and this is in line with the Ndlovu decision, the hearsay evidence may be provisionally admitted in terms of subsection 1b. That is the provision on which the complainant sought the admission of the hearsay evidence. If the court is informed that the person upon whose credibility the probative value of such evidence depends will himself testify in such proceedings, provided if such a person does not later testify in the proceedings, the hearsay evidence shall be left out of account unless the hearsay evidence is admitted in terms of one of the exceptions under C, my lord, subsection paragraph A of subsection 1, or is admitted under paragraph C. No such application was ever brought by the complainants before your lordship. So therefore, Ndlovu decision then is instructive in that, and that's the submission, that the trial court must be asked, and that's at paragraph 47, clearly and timeously to consider and rule on its admissibility. It was not my duty, my lord. It was the duty of the complainant to prove its case and to ask for such a ruling. Such a ruling was not given. But now the difficulty, my lord, and this was brought to their attention, this cannot be done for the first time at the end of the trial, nor in argument, still less in the court's judgment, nor on appeal. So, my lord, we submit that they don't pass the first requirement as submitted by Mr. Ismail earlier today, and they did not prove that the words that they allege were in fact published by the 8th respondent. This then goes also to the fact that where criticism is leveled against the respondents, and in particular, I believe it to be that of the 8th respondent, as to the pretrial issues. In fact, the pretrial minute, as I understand it, was never signed by the 8th or by Mr. Krause for the 8th respondent, because what was contained in there, we contended was not correct. From the outset, and that is clear from the proceedings, we sought the original of this document. We then took the trouble of getting an expert in these matters to the assistance of the court. Yet the complainant sought to disallow that evidence, and your lordship, as I submitted earlier, ruled that that evidence would not be allowed. I cannot take that any further. That is the ruling of the court, and I respect that. But that goes to that aspect. The other aspect is the late discovery of those screenshots, my lord. But that goes then to what we submit in our heads of argument as to the constitutional right guaranteed in section 34 of the Constitution, where any person is afforded a right to have any dispute resolved in a public hearing and in a fair manner. We submit that that right was not given effect to in the circumstances of this case, and I submit for that reason, your lordship could also find that the complainants did not make out a proper case. But more importantly, in the heads of argument, or not more important, but of importance, in the heads of argument of the complainants, they submit that these proceedings are inquisitorial and the normal rules of evidence don't apply, etc., and they refer to various decisions. I submit that that can never be the case. What is suggested is that there should be an expeditious, I do not take issue with that, it should be expeditious, it should be informal, and the matter should come to finality as soon as possible. But if one has regard to the regulations, and I just refer in the bundle prepared by the complainants, at page 26 thereof, it the authorities bundle, and subsection 7 of regulation 10. It says the powers and functions of the court. At 7, it says, save as otherwise provided for in these regulations. Now, I'm unable to find where it is otherwise provided for. In the law of evidence, including the law relating to competency, compellability as applicable in civil proceedings, apply in respect of an inquiry, provided that in the application of the law of evidence, fairness, the right to equality, and the interest of justice should, as far as possible, prevail over mere technicalities. The point we raise is not a mere technicality. The fairness aspect, the right to equality, and the interest of justice is a two-way street. It doesn't just find application to the complainants. It finds application to the respondents equally. My Lord, as to the comment by the fourth respondent, and he testified in the matter, and we know what his evidence is. Our submission, or the submission that is made on behalf of the fourth respondent, is that in the circumstances, it is taking it somewhat too far to try and link in the circumstances and in the context of which that statement was made, that this applies to the Chinese community, and in particular to the complainant's members at large. Mr. Horn's evidence was clear that he made no post on the carte blanche Facebook page. The post was made in respect of the Mail and Guardian article. And that also then goes likewise as to what the complainant submits, the probabilities of all these comments now appearing on the Facebook page, of which carte blanche or wherever. Those are later comments. This comment was made in respect of an article, as I understand it, that was before the carte blanche program. It relates specifically to the gangs and the syndicates. Any reasonable reader on an objective basis, and that's a question that your lordship will have to answer. Ultimately, that, as Mr. Ismail submitted, is that the question, or Mr. Wink, should I say, is the question for the court to answer. Anybody reading that article and reading the comment made by Mr. Horn, where he says, Jonathan, John Ashuan, thank you, with the emojis. I say personally, I'll say wipe them out. It could never be construed by any reasonable reader to be a comment that Mr. Horn intends to incite violence and harm against the greater Chinese community. That is, with respect, my lord, on my understanding and in the circumstances, to put it beyond what this act intends and the mischief that the act in question attempts to cure or to stop. Because there has to be obviously a balancing, we know that. And in the beginning of the heads of argument, we quote that one of the essential foundations of a democratic society is the right to freedom of expression, its importance to a democratic society, and applicable not only to information or ideas that are favorably received or regarded as offensive or as a matter of indifference, but also to those that offend, shock, or disturb. Such are the demands that pluralism, tolerance, and broad-mindedness, without which there is no democracy. So the difficulty, as I see it, and Mr. Ismail, in his opening address, made some comments and observations as to the nature of social media, that it's broader, it can spread. It's not just like a newspaper where there's an edition, a Saturday afternoon edition of the Star. There's an article, some people read it, then gets chucked in a cupboard somewhere in somebody's house, and then it's not circulating anymore. We understand that, but we also need then to put that into the balance of this new world of social media, this ever-growing world, that there are reports. So does this thing then go to the point where newspapers or like the Maverick or social media houses cannot report on anything controversial, then they can't allow a comment section, as we see in all of these articles, Facebook postings. There's a section for comments, and where these things are shocking and they do create some outrage, one would expect that there's going to be people in the community that are going to express themselves perhaps more vividly than others. So that may even be something that the legislature might need to look at further. But this surely cannot be visited in the context of this case on Mr. Horn. And the difficulty that we face, and I understand what Mr. Winks is saying, the intention of the writer doesn't, or the commenter isn't a factor. That creates a further problem, man. There has to be some balancing, because the way I understand that, and my submission is, that comes back to what is said in the quote in the beginning of the heads. It's not only information or ideas that are favorably received, it also applies to those that offend, shock, and disturb. So that would then take away that right totally. It wouldn't even be a balancing or a limitation of the right to freedom of expression in section 16 of the Constitution. My Lord, then
sorry, can I just find out that quotation about the right to freedom of expression? Is that what is quoted in this case of Islamic Unity Convention, or where do you get that?
That's as I understand it, my Lord, at paragraph 28.
At paragraph 28.
Yes.
Now I'm looking at paragraph 1 where you so you're saying I'm asking about on page 2 of your heads, you refer to the right to freedom of expression is applicable not only to that, and then you say see Islamic Unity Convention. Is that where you get this quote from?
As the court pleases, my Lord.
Okay, thank you. All right.
My Lord, then the submission then in that regard, as I've submitted to your Lordship, is that in respect of the first respondent, that's not the first, the eighth respondent, the first ground which must be proved as submitted by the complainant, they don't pass that hurdle. That's the end of that case. The issue in respect of the fourth respondent, my Lord, even though the statement that they complain of is admitted by Mr. Horn, I submit that that statement does not, and they did not prove that that statement satisfies the second requirement, that the words were based on one of the prohibited grounds, that them can be inferred by a reasonable reader objectively to refer to the Chinese community at large. We can only refer to the gangs or the syndicates. And they don't then get past the second and third ground. If I may just be granted a moment, my lord.
Okay.
My lord, as to the reliance, and I submitted earlier to your lordship, as to the reliance on the letters written, which we submitted and which your lordship ruled, well, we submitted, sorry, they were privileged and as such inadmissible, but we also raised a second ground in that regard, being not only are they inadmissible on the basis of being privileged, but they're also inadmissible on the basis of being hearsay. Now, the difficulty faced there by the 8th respondent especially is that your lordship in a further directives hearing ordered that the documents are what they purport to be without the proof of the content. They are deemed to be written by the person and address, date and time, etc. The standard clause that is sometimes agreed to between parties in litigation. So I cannot take issue with your lordship's ruling in that regard in these proceedings. But what I can submit to your lordship is, even based on that ruling by your lordship in the directives ruling, notwithstanding our submission, and I just pointed out to your lordship, and it's not an attack on your lordship's ruling, is that I understand the regulations to grant or provide, let's say, make provisions for administrative rulings, not substantial rulings on substantial issues of law or evidence, as I've submitted on previous occasions to your lordship. The law of evidence is not just a procedural aspect. The law of evidence is together, is entwined in that is a procedural aspect, a manner in which we perhaps prove evidence, and also a substantive element of the law. So the submission there, my lord, is that notwithstanding your lordship's ruling, we still submit that the complainant failed in regard to that letter, and where they submit, and Mr. Ismail submitted it this morning, that he said the admissions made, admits from his own, the words I wrote it down here, admits from her own lawyer's correspondence, or there I wrote here, admits from own lawyer's correspondence. If they want to rely on an admission or a confession, the law is clear. Then they should have requested that a trial within a trial be held to prove that admission or confession. Then Mr. Nolte or whoever was relevant would need to have been called as a witness to prove that admission. So until that admission is proved, it also cannot serve before your lordship.
So, sorry, are you then saying then that the respondent would have then acquired an affidavit or whatever form of document from Nolte attorneys disavowing any knowledge of the contents of those letters? How do you say that would they have dealt with it?
I look at it, I think, the other way around, my lord. So your lordship ruled that those letters do not attract privilege, as I understand your lordship's ruling in just in loose terms. Lordship, no, those letters are admissible in evidence and they're not privileged. But the objection to the correspondence was twofold. It was that it was privileged. Your lordship ruled it's not privileged. I cannot do anything about that in these proceedings. That's your lordship's ruling.
So
the content thereof is hearsay. they would have to then have proved the content of that letter. And if they wanted to rely on an admission, so they say there's an admission that she made, that the 8th respondent made the post, complained of. It's admitted in the 4 letters. They would need to prove that admission, and the only way we prove admissions is with a trial within a trial model. That's how I understand the general rules. And that's not technical. The regulations clearly say that the law of evidence applies, but only save as otherwise provided for in the regulations. The regulations don't otherwise provide that privileged communications may be used in these proceedings. Your Lordship has ruled that we don't take issue with at this stage. But nowhere in these regulations does it provide otherwise that privileged communications may be allowed, or that any admission written in a letter which appears to be a letter from somebody's attorney can be used as an admission against the person against whom it's tendered, because then the normal rules of evidence must apply. That's our submission in short. My Lord, and I don't want to take the same approach as the complainants have, their scathing attack, not only on the 8th respondent and the 4th respondent, but it appears that there's an attack on myself personally and that of Mr. Krause. But in the same breath, one can sit here, and that's not our intention. We could dredge up a host of issues. For example, the late discovery. The issue that we raise, and it's not to be a submission to put anybody in a bad light. The submission that we raise at page 12 of the heads of paragraph 38 onwards is that the approach adopted by the complainants is that this must be an inquiry. But they strenuously oppose evidence that would be of assistance to the court by way of your Don, notwithstanding the fact that it's an inquiry. So it appears that the approach adopted is, if it suits the complainant's case, then it's permissible. If it does not suit the complainant's case, then it must be impermissible. And that goes back to our submission, my Lord, that it must be a fair hearing. My Lord, I've dealt with that. My Lord, just to clarify on the aspect, my attorney just points out something to me, just to clarify the issue with what we submitted as to the admissions, would be a trial within a trial. Nullity would then have to be called, or your Lordship would have seen that those letters were dictated, not signed by him, and it was his assistant that simply typed the letters out and sent them. I forget her name now, but I can find, if relevant, I can get your Lordship to the page. Those persons would then, within the trial within a trial, be called, and we would establish the basis on which the alleged admission was made, because it would be incumbent, and that's the point, and I failed to say that. If the complainants wish to rely on an admission, they need to prove that that admission, or confession, in this case they say it's an admission, but if it was a confession, they would have to prove that that admission was made freely and voluntarily. With the instructions, in other words, would also come into the mix, I would submit.
Yes, can I just find out, in the, I'll have a look at that, in the application to strike out, did the 8th respondent say that, or the 8th or the 4th respondent say that, I never instructed my attorneys to say what they are saying in those letters? And therefore, I disavow any knowledge about what is contained in those letters.
I don't believe there is such an affidavit.
Yes, but in the application to strike out the contents were not disputed. Is that what can I take that? The contents were not disputed, safe to say that it was privileged information that is not admissible. That was the only thing that was raised.
What was raised is that it's privileged.
Yeah.
One, it's privileged, and two, the evidence contained therein is inadmissible against the complainant. The admission.
Yeah, okay, thank you.
My Lord, as to the discrimination aspect, my understanding, and I hear the submission, and that's an issue that your Lordship will have to determine, that in legislation, if a certain word is given a definition, as in the case of the act in question, discrimination is defined in the act to mean any act or omission, including a policy, law, rule, practice, condition, or situation which directly or indirectly imposes burdens, obligations, or disadvantages on, or withholds benefits, opportunities, or advantages from any person on one or more of the prohibited grounds. I would submit that definition must also be applied, as I understood from Mr. Winks' submissions, as to Section 7 of the Act, my Lord, where discrimination is used. My Lord, then, to conclude, in conclusion, and we submit that no case is proved against the 8th respondent, so this wouldn't as such be relevant. But insofar as the 4th respondent, sorry, the 4th respondent is concerned, if your Lordship, by some stretch with respect, I submit, by some stretch, can objectively conclude that the word them, in the context of what that statement was made, then I submit that the recent case of Kulani that has been referred to and that we waited for would also be instructive in these circumstances, in that at paragraphs 176 to 182, as I understand it, in assessing the statements, one has to also then look at to the identity, the status of the speaker, the context, my Lord, the context in which the comments were made, the impact of the speech, and the likelihood of inflicting harm and propagating hatred. So, my Lord, as I understood it from the evidence, and that was in line with the Supreme Court of Appeal decisions, and the evidence, and I'm not too sure if it was Yak or Mr. Yak or Hawk, where the question was put to her, whether they are aware of any impact or any harm that was caused as a result of these comments by the 8th respondent, and there was nothing shown. The likelihood, my Lord, I would submit, is not only something, is not something that we must grab out there where it's not even tangible. There should be some evidence, I submit, that shows that there was a likelihood. Because if the likelihood is too far removed or too remote, it's not a likelihood, man. So in that respect, the Constitutional Court says that one must have regard to identity and status of the speaker, the context, the impact, and the likelihood of inflicting harm and propagating hatred. So we don't know much about that. There doesn't seem to be much evidence about that. But what is and this is probably just as a matter of interest. Document is a fairly comprehensive document. It's a struggle for realization of the right to freedom of expression in South Africa, in Southern Africa. There, with reference, these same principles are set out that are set out in Kulani, but in this article it goes further and says that it includes considerations of the social political context, no difficulty, the position or status of the speaker, and here is the intention of the speaker, and that appears to be where the Constitutional Court and the broader African aspect, and probably even internationally, seems to depart as to the intention of the speaker is of no relevance. That puts us in somewhat of an invidious situation, especially for the fourth respondent, as he clearly gave evidence. His evidence before the court was that in no way, the correspondence referred to says in no way was this ever a reference to the complainant, its members. It was a comment in response to the article relating to the illicit activities relating to the donkey skins being exported.
But wouldn't one have expected the fourth respondent to have said, as for me, I say, wipe out these gangs that kill the donkeys?
Well, my lord, if we're talking in the social media space or platform, I would submit that it would be obvious to an objective reader when looking in context at what the comment is about. So we have an article dealing with illegal activities. We have a comment made by a reader. I say wipe them out. That them can never refer to the greater community of Chinese people or whoever. Not whoever. Just because the skins are being exported in terms of the in terms of the article to China, I would submit that an objective requires reasonable. A reasonable person, objectively viewed, reading that comment would never conclude that that comment is to the extent, in that context, to wipe out all Chinese people in South Africa or globally. It's just illogical, with respect. My lord, then I'm not going to, we deal at paragraph 66 as to the onus in the heads. My lord, then in the circumstances, and Ismail submitted to your lordship as to the costs, my clients already face several cost orders against them. Those cost orders were made on just the normal scale as I understood it. I submit that in the circumstances of this matter, it cannot be said that the respondents did not exercise their rights to come to court, to challenge the evidence, to put their version before the court, and as a result of issues that arose, and your lordship also commented at one stage in this inquiry that, gentlemen, we know things get heated. Let's just calm out. Let's just calm down. Let's just deal with the matter. It's not something that's unexpected, especially probably in matters of this nature. To say, well, now the fourth and eighth respondent must be punished for exercising what they believed to be their rights in terms of the act, in terms of the regulations of this act, in terms of what the rules of evidence provide, what the Constitution guarantees them to a fair hearing where the rule of law will be applied. So we submit as to costs that we should not pay the cost if your lordship finds against us, which I submit your lordship shouldn't, but more importantly, as submitted in the complainant's heads, that even if the 4th and 8th respondents are successful in defending this matter, that they should be deprived of any costs would also not be just, as your lordship clearly through, as your lordship is aware, clearly through the process of this matter, cost orders were made where the court didn't agree to the one side, and if your lordship is in agreement that no case has been made out against the 4th and 8th respondents, there's no reason that they should be deprived of their costs. This was a hotly, let's say, for the lack of a better word, contested matter. The complainant is represented by 4 advocates. So the issues involved here, as submitted by the complainants to them, is substantial. As submitted by the 8th respondent and the 4th respondent, it is substantial to them. If they succeed, I submit the normal rules should apply. Costs should follow the event, not punitive costs. There's no basis for punitive costs. And as I said, we find ourselves in an invidious situation, as your lordship already made certain costs in relation to the argument relating to the late discovery. We deal with that in our heads of argument. Sadly, I only found the screenshots in question the day before the public holiday in the March. We, as I recall, came into possession of that on the Friday. The matter started on the Monday. So it's not even a court day. Then we raise a concern that the matter is not ready for trial, and a cost order is made against the 8th respondent. So it's submitting that basis, and in light of that, that there's no basis that we should be deprived of our costs. So, my lord, just one last thing, just to draw your lordship's attention. And we didn't hear Mr. Ismail on this, and I'm sure perhaps he's going to address this in his response to our heads of argument. But just to draw your lordship's attention, and it was clear from the record, as I understand it, that he would be seeking the admissibility of the inadmissible evidence on the basis of section 15 sub 3. So we make the submission there. 15 sub 3 of the ECTA Act provides, in assessing the evidential weight of a data message, regard must be had to the reliability, manner in which the data message was generated, stored, or communicated, the reliability of the manner in which the integrity of the data message was maintained, the manner in which the originator was identified. Important point, my lord, and any other relevant factor. They never laid evidence on any of these. We in fact, the 8th respondent and 4th respondent were in a position to, and as I've submitted, I cannot take that point any further because your lordship made a ruling, which ruling I must respect. The manner in which its originator was identified, Jordan was in the prime position to be of assistance to the court in that regard. So, my lord, those are our submissions. We submit that the case against the 8th respondent and the 4th respondent must be dismissed, and it must be dismissed with costs.
Yes, thank you. Thank you, Mr. Garvey. Honourable Ismail, in response. Hello, Advocate Ismail.
Yes, thank you. Thank you, Justice Makume. We do have a reply. Mr. Winks will be dealing very briefly with the submissions in relation to the 4th respondent, and I'll be addressing the remaining submissions. Justice Makume, the reply will also be short.
Okay.
I want to start out with a question you put to Mr. Garvey based on his heads. His heads of argument, the 4th and 8th respondents' heads of argument, start out with an introduction. They state at paragraph 1, and it's important I ask you to have regard to the document. They state at paragraph 1 under the introduction as follows: the right to freedom of expression and its importance to a democratic society has been described as one of the essential foundations of a democratic society. Then he continues, the right to freedom of expression is, quote, applicable not only to information or ideas that are favorably received or regarded as offensive or as a matter of indifference, but also to those that offend, shock, or disturb. Such are the demands of that pluralism, tolerance, and broad-mindedness, without which there is no democratic society. And then in parentheses, he sources that quote, and he says, see the Islamic Unity Convention versus Independent Broadcasting Authority and others case, the Constitutional Court case of 2002, volume 4, 294, at paragraph 28. Excuse me. Now, your lordship asks Mr. Garvey whether that quote comes from that judgment. And he tells you it does. Now, the question your lordship put to him was a particularly important question because it is around this quote, placing freedom of expression as a pivotal principle of a democratic society. It's around this quote that he has built his heads of argument in his case. Now, I quickly looked up the case while Mr. Garvey was making his submissions. The case I find with Islamic Unity Convention and the Independent Broadcasting Authority, if you bear with me a moment, Justice Makume, is indeed a case of the Constitutional Court. And it is also a case that was decided in 2002. It appears to be the very same case that Mr. Garvey is referencing. The author of that unanimous decision was Justice Pius Lunga, the acting DCJ as he then was, the acting Deputy Chief Justice. Now, the first thing that strikes me is that these words don't find themselves in paragraph 28 of the judgment. In fact, paragraph 28 of the judgment deals with something altogether different. These words find their place in paragraph 26 of the judgment. But these words, importantly, Justice Makume, are not the words of the Constitutional Court. Let me read from the judgment. At paragraph 26, Lunga DCJ is talking about freedom of expression and its importance to society, democratic society. And he quotes the European Court of Human Rights. He says, in Handyside versus the United Kingdom, the European Court of Human Rights pointed out that this approach to the freedom of expression is, quote, applicable not only to information or ideas that are favorably received or regarded as inoffensive. In other words, the Constitutional Court is quoting the European Court of Human Rights in the Handyside decision. Now, it was misleading to suggest to you in written argument, and again to repeat it in oral argument, that that is a quote of the Constitutional Court, particularly when you specifically ask the question of Mr. Garvey. The misleading nature is compounded when Mr. Garvey fails to bring your attention to the very next paragraph in the judgment, paragraph 27 of the Constitutional Court judgment. And it reads as follows: the pluralism and broad-mindedness that is central to an open and democratic society can, however, be undermined by speech which seriously threatens democratic pluralism itself. Section 1 of the Constitution declares that South Africa is founded on the values of, quote, human dignity, comma, the achievement of equality and the advancement of human rights and freedoms, unquote. Thus, comma, the court goes on, thus, comma, open and democratic societies permit reasonable proscription of activity and expression that pose a real and substantial threat to such values and to the constitutional order itself. Many societies also accept limits on free speech in order to protect the fairness of trials. Speech of an inflammatory or unduly abusive kind may be restricted so as to guarantee free and fair elections in a tranquil atmosphere. That was the context in which the debate's playing out. So what the court has indicated in that case is that freedom of expression is not the be-all and end-all. Indeed, in our constitutional dispensation, it is balanced against other fundamental rights. Those rights protect equality and dignity. It might be different in other parts of the world. Now, it is most unfortunate that the heads of argument of the fourth and eighth respondent selectively quote and misrepresent that decision, and then the misrepresentation is propagated further in oral argument as the very basis for the fourth and eighth respondents' representations. That's the first point I'd like to deal with. Justice Makume, there is a second point I'd like to deal with, and it concerns the case against the eighth respondent. I'm not sure if counsel for the eighth respondent appreciates the nature of the case that has been made out against the eighth respondent. The argument being made is that the evidence of Ms. Emma Sadler is inadmissible. Now, it is a curious argument. Mr. Garvey doesn't tell you how rendering her evidence inadmissible will thwart the case against her. He doesn't tell you that. He doesn't say if this particular piece of evidence, excuse me, he doesn't say to you if this particular piece of evidence is no longer there from Ms. Sadler, because it is an inadmissible on the following basis, then the case against the eighth respondent falls. Instead, he adopts a blanket approach. All of our evidence is inadmissible, he says. Now, that's strange. Let's look at where Ms. Sadler's evidence is being used in order to found a case against the eighth respondent. Your Lordship will recall that we said the case against the eighth respondent has to be demonstrated on 3 legs. The first leg is that the impugned message was published on the Carte Blanche Facebook webpage on the 31st of January 2017 by a person using the pseudonym or the username Marietta V.D. Linda de Klerk. That was the first evidential leg. And where did Ms. Sadler's evidence come in? We said that has been established. We said that has been established, and we cited 4 bases for that. We said, firstly, we had a screenshot of the publication of that comment on the Carte Blanche Facebook page made on the relevant phone, generated by that phone. And the screenshot constitutes the best evidence of the fact, given that the web page has been cleared of comments. Now, I'm not sure I understand where Ms. Sadler's evidence is inadmissible on that score. If it is to be argued that the screenshot is a data message, and as it appears on her original phone, which was provided to the 8th Respondents legal team, we have independent, separate, self-standing evidence of Miss Emma Sadler. This is where her evidence comes in, Justice Makume. She said she personally viewed that comment made by the username Marietta VD Linda de Klerk. Not by the 8th Respondent, by that username. She personally viewed that comment on the web page at the time. She personally evaluated that comment at the time. She personally chose that comment to include as part of this litigation because she felt it was egregious. She did that at the time. She asked her associate at the time to take a screenshot of it, and she transcribed that comment personally. Now, what part of that is inadmissible? Justice Makume. The truth of the matter is nothing can be contended to be inadmissible in that regard. To the extent that we rely on Ms. Sadler's evidence on that score, it is entirely admissible. There is nothing conceivably inadmissible with her lay evidence in that regard. And that evidence merely goes to demonstrate that the impugned comment was made at the time on the relevant Facebook page by a person using the username Marietta VD Linda de Klerk. Therefore, Mr. Garvey's general submission that you must disregard all of Ms. Sadler's evidence on account of the fact that it's inadmissible is, with respect, a misnomer. It doesn't make any sense. He doesn't pinpoint any evidence. He doesn't tell you why that evidence is inadmissible. And on the basis of the evidence we have relied upon of Ms. Sadler, there is no conceivable basis to object to any of that evidence. It is certainly not expert evidence. And it is certainly not hearsay evidence. In other words, she says, I, Emma Sadler, viewed that comment which appeared on the Carte Blanche Facebook page under that username on that date and time. I saw it. That's what the comment was. I recall it. That is the end of the complaint by Mr. Garvey relating to Ms. Sadler's alleged hearsay evidence. That's the end of it. And we've established that first proposition. But we have a second proposition that we need to come home on. We need to demonstrate to this court on a balance of probabilities, as I've indicated in my initial submission, that there is a link between that username, the person using the username Marietta VD Linda de Klerk, who posts that impugned comment, and the actual person, the respondent, the 8th respondent, who coincidentally or otherwise has the name Marietta van der Linde de Klerk. We need to demonstrate on a balance of probabilities that there is such a link. Now, I took your lordship through that. I said the evidence clearly demonstrates that link. Nowhere in that evidence did I point to Ms. Emma Sadler's evidence. In other words, I said the link is established because of the admission through lawyers' correspondence. I said the link is established through her own version she put in cross-examination, where she effectively admits she's a Facebook user and posts on Facebook. The link is reinforced by the fact that she refuses to give evidence and expose herself to cross-examination on matters directly within her unique knowledge. The link is furthermore reinforced by the funnel approach, the rigorous funnel approach that was employed by the TCA technical team under Mr. Erwin Pon at the time, the link is furthermore established and reinforced by the fact that Mr. Pon thereafter sought out Marietta van der Linde de Klerk, pointing out in his evidence it was a unique name. Every time he picked her up on social media and disclosed that to her, she shut it down. He identified her profile picture as the person in court. That is how the link was established, Justice Makume. Nowhere do we rely on Miss Emma Sadler's evidence for that link. And the third basis for our claim against the 8th respondent was an interpretation of the wording. And we indicated that was an objective interpretation. Mr. Garvey appears to take issue with that. If I could refer you to the Constitutional Court decision in Kwelani, nothing could be clearer. Mr. Garvey has suggested that the views of the author and the intention of the author are relevant. Clearly, he does not seem to accept the Constitutional Court's decision in that regard. The court held as follows at paragraph 96. Before this, and I quote, before this court, the parties debated whether the phrase, open inverted commas, that could reasonably be construed to demonstrate a clear intention, close inverted commas, and I'm adding for purposes of section 10, postulates a subjective or objective test. In my view, it is plainly an objective standard that requires a reasonable person test. This is based on the gloss, reasonably be construed, and to demonstrate a clear intention, those words in inverted commas, implying an objective test that considers the facts and circumstances surrounding the expression and not mere inferences or assumptions that are made by the targeted group. And critically, this is what Justice Majid, on behalf of the unanimous Constitutional Court, says at paragraph 97. This approach accords with the interpretation advanced in South African Human Rights Commission versus Khumalo, and that's the decision of Sutherland J, that, and we quote, the objective test in section 10(1) of the Act implies in the terminology used to articulate it that an intention shall be deemed if a reasonable reader would so construe the words. Because the objective test of the reasonable reader is to be, it is the effect of the text, not the intention of the author, that is assessed, unquote. I endorse this approach, says Majid J. It is consistent with our jurisprudence concerning similar issues. Therefore, that debunks the approach Mr. Garvey is seeking to advance before this court. The second point Mr. Garvey raises against the 8th respondent was his opening point. He says there were issues of inadmissibility that this court did not rule upon, and that ought to have been ruled upon not at the end of the trial, but ought to have been ruled upon at an earlier point in time. Now, we have already demonstrated to you, Justice Makume, that even if you accept Mr. Garvey's objections, excuse me, all of Ms. Sadler's evidence can't be ruled as inadmissible. We have used a very narrow ambit of Ms. Sadler's evidence, which I've described to you, which is lay evidence that doesn't constitute expert evidence, that does not constitute hearsay evidence, that is within her direct and personal knowledge, to demonstrate the case against the 8th respondent. But the problem is is compounded further for the 8th respondent, because it is incorrect for the 8th respondent to suggest they are not playing games with this court. Immediately after the complainant closed its case, it sought to invite the court to deal with any issues of admissibility that Mr. Garvey and his clients had. You will recall, I've mentioned this before, I will deal with it in our right of reply. Mr. Garvey responded in the most aggressive fashion imaginable. He attacked the court, he attacked me, he interrupted me no fewer than 12 occasions. He bullied and browbeat and badgered the court, and he extracted what he sought. Namely, he extracted from the court a ruling that there is no need to make an issue or to make a ruling on any of those issues of admissibility. That's what he wanted. So the 8th and the 4th respondent refused to allow the court to make that ruling at a time when it could make the ruling. And we warned them that this is the stance you're adopting only because you want to argue down the line, possibly on appeal, that the court has committed a procedural error. But it doesn't lie in your mouth, 8th and 4th respondent, to argue that the court failed to make a ruling when you strenuously refuse to allow the court to make a ruling. It's just absurd. It's nothing less than a risible abuse, Justice Makume. The next question I want to deal with concerns the question of the admission by the 8th respondent that she was in effect the author of the impugned comment in Mr. Nolte's ruling, in Nolte Incorporated's various letters. Now, the argument raised by Mr. Garvey is that those are without prejudice correspondences. He says to determine their admissibility, you need a trial within a trial. Justice Makume, I'm not a practitioner in our criminal courts, but I do know from my recollection of criminal law that that is a classic instance where, in order to determine admissibility of statements in the criminal context, you have a trial within a trial. In the context of these proceedings, however, that sort of terminology, that adversarial terminology rooted in an accusatory criminal context, has no role to play. Once more, the 4th and 8th respondents are misconceiving the nature of proceedings we're involved with. Instead, what has happened here in relation to those statements is the 4th or the 8th respondent brought an application to strike out. As you correctly inquired, Justice Makume, and the response was provided to you, there was no allegation by the 8th respondent in her application to strike out that she didn't make those statements. She simply said those are privileged. I'm employing, in other words, she said, I'm employing the rule of evidence that says you are not entitled to use a privileged document. Now, again, I refer you to Regulation 10.7, which Mr. Garvey took you to as well. It says, save as is otherwise provided for in these regulations, the law of evidence, including the law relating to competency and compellability, as applicable in civil proceedings, applies in respect of an inquiry. Now, Justice Makume, we've dealt with this in the course of the argument dealing with the application to strike out. We pointed out there, and we repeat the submission, that this statement is subject to the important proviso, provided that in the application of the law of evidence, fairness, the right to equality, and the interests of justice should, as far as possible, prevail over mere technicalities. Privilege is not something that is asserted and can never be given away. Privilege turns on interests of justice and public interest. In the circumstances of this case, to the extent that there was any without prejudice privilege attaching to Nolte Inc.'s correspondence, that we submitted to you and you found was overridden. There is no question before this court in relation to the present proceedings about privilege arising. That issue has been dealt with. Therefore, it doesn't lie in the mouth of the 8th respondent to resurrect the issue in a bid to avoid liability. If we're wrong on that issue, Mr. Garvey, obviously, and his client can take us an appeal, and we'll deal with that issue and its implication for this court's finding in one case, in one fell swoop on appeal. But it doesn't lie in his mouth to ask you to revisit an issue upon which you've made a final ruling. The final point I want to deal with concerns the question of costs. I listened to Mr. Garvey very carefully, and I struggled to reconcile his submissions with what his heads of argument state and what his client's conduct amounted to as set out in our heads. In relation to the question of costs, you will see from paragraph 69 of the 4th and 8th respondents' heads. From 68, they ask for a dismissal of the complainant's complaint with costs. And in 69, they ask for those costs to be on the attorney and client scale. So they want costs against the complainant on the attorney and client scale. It seems that the 4th and 8th respondents must have finally read our heads of argument, where we draw on their conduct from inception to date. And they clearly realized they're in a bit of a pickle, so they can't advance that aggressive costs order against the complainant, the victim. So they water it down. Now, I listened very carefully to what Mr. Garvey had to say, and let's see what he said. He said, in essence, the following, Justice Makume. He said that my clients can't be faulted. They didn't do anything unlawful. They were merely exercising their rights. But on his logic, Justice Makume, taken to its conclusion, it would mean that any litigant who comes before any court in this land, provided they can say, I haven't broken any rule, any black letter law, any fiat, any ordinance, I've complied in accordance with the rules, and therefore my conduct can never be abusive, thereby attracting an adverse cost order. Now, that merely need be said to be demonstrated as incorrect, because it's very clear that a litigant can pursue all their rights in terms of the formal black letter of the law, in terms of compliance with the rules, but they can do so in a deliberately abusive manner. And that is precisely what has happened here. They have done so in a deliberately abusive manner, which is inexcusable. I have taken your lordship through, albeit in a very fleeting fashion, through the conduct we complain of the fourth and eighth respondent. It is set out in detail in the heads. We would respectfully ask the court to look at the transcript to see what in fact has transpired here. And the justification submitted by Mr. Harvey for their conduct is no justification whatsoever. In fact, it's an aggravation because in their heads, they asked for costs on an attorney-client scale. We would in fact go further, Justice Makume. We would respectfully submit that irrespective of the outcome of this case, irrespective of how you find against the fourth and the eighth respondent, the complainant should get its cost, at least on a party and party scale, but we submit on an attorney and client scale for the reasons we have identified and taken the trouble to set out in meticulous detail with reference to the underlying documents. The bold assertion, entirely unsubstantiated, made by Mr. Garvey in his heads, quite frankly, is nothing we can respond to. If your lordship just bears with me a moment, I just want to check with my team to see if there's anything else.
Okay.
I'm indebted to you. Thank you, Justice Makume. Advocate Winks just has one very brief submission to make in relation to the fourth respondent in reply, with your leave.
Well, yes, thanks. Whilst you're still there, in your submission about cost on an attendant client scale, I've not heard or seen anything where what do I do about counsel's costs, fees? I haven't seen anything. Normally, we're asked to give costs which will include counsel's fees, but I don't know, and also whether it should include all the counsels or two counsel or whatever. There's nothing that I've been given.
Justice Makume, we just got off a call with one another. We do, our submission is that it should include the costs of counsel fees. It should include more than one counsel, but we are reluctant to identify the number yet without carefully considering the position and looking at comparative law. Can we address the question of how many counsel we're seeking the costs of after we've considered the position and the case law more carefully? It's going to be at least the costs of two counsel. Whether we can ask for the costs of more than two counsel is something we're going to consider amongst ourselves and respond appropriately. I know our client would want the costs of more than two counsel, but we can't make that submission without it being carefully considered, Justice Makume.
Okay.
All right.
Thank you. I suppose that Advocate Garvey will also have a right to respond to that on the issue of the costs.
On the issue of costs, we're happy for him to have a second bite on the cherry, but just on the issue of costs.
All right. Advocate Wings, please come in.
As it please you, my lord. I have two very short submissions to make. It's about Mr. Garvey's references to the judgment of Puelane, the Constitutional Court judgment. So Mr. Garvey indicated that the legislature needs to fix this problem, that intention is irrelevant. That's not the function of this court, is to say what the legislature should do. This court has to apply what the Constitutional Court has affirmed in Puelane, and that is, as Mr. Ismail took you to in paragraph 97, I quote, "It is the effect of the text, not the intention of the author, that is assessed." Now, I remember at some stage in responding to an objection by Mr. Garvey, I did advise him that in terms of the Equality Court jurisprudence, intention of the speaker can be a relevant factor for remedy, perhaps a mitigating factor or an aggravating factor, depending. But he hasn't argued that, that Mr. Horn's subjective intention should be a mitigating factor for the purposes of remedy. Despite me having placed a number of aggravating factors ahead of him, he didn't address those. Now, I would submit briefly that the court cannot, on the face of it, take Mr. Horn's professed innocent intention as a mitigating factor anyway, because it's inconsistent. His professed innocent intention is inconsistent with his affidavit, where he says, the facts are the facts. Chinese people are the bad guys. Chinese people are killing donkeys. And here are some photos of donkey skins that Chinese people are skinning. So you can't say on the one hand, no, my intention was just to refer to gangs. And then on the other hand, say, the facts are the facts. Chinese people are the bad guys. You know, this is attributable to Chinese medicine and Chinese gangsters and Chinese consumers. So with respect, the court cannot even take this supposed subjective innocent intention as a mitigating factor on remedy. Certainly, it can't be taken into account on the merits, whatever Mr. Garvey might think about how the legislature must fix what the Constitutional Court has done in Kwelane. Subjective intention is irrelevant to the merits. It's the impression of the reasonable reader. Then the next issue from Kwelane is where Mr. Garvey quotes selectively that says that you must look at the likelihood of harm. And he says, no, well, I questioned Park and Professor Park and Mr. Wing and others and Ms. Diap about whether they were aware of anybody having been attacked as a result of these comments. Now, the Kwelane judgment, if my learned friend had read it completely, is very clear on this issue. In paragraph 107, it says, considering next the phrase to incite harm, it is imperative to point out at the outset that there is no requirement of an established causal link between the expression and the actual harm committed. They go on to quote from international treaties that hold that to be the case. Now, and it goes on to paragraph 111. I won't read all of it. There's no requirement to, my Lord can have regard to it. There's no need to waste time. But they conclude again in 111, our law does not require a causal link. That there is no requirement for a causal link is clear from the Equality Act itself. To require a causal link would in and of itself undermine the very same objectives of the Equality Act to prohibit unfair discrimination, in that not every instance of harmful or hurtful speech will result in imminent violence. There may be expression which certain groups find hurtful or harmful, which does not actually result in violence, but that does not take away from the fact that such expression would have been hate speech. So, in this case, it's certainly not the case that you have to prove that some violence ensued we must produce some witness saying, yes, I read Mr. Horn's comment and then I decided to beat up Chinese people. That is ridiculous and it's not required. In any event, harm, as the Kwelane judgment makes abundantly clear, is not limited to physical harm. It also refers to deep psychological and emotional harm, as well as the harm to the fabric of society in its nation building and reconciliation efforts. And that harm is not only reasonably apprehended, it's been established on the evidence that this isn't a case of somebody, making racist speech, in a cloistered white supremacist environment, and Chinese people didn't hear it. A place where Chinese people did hear it, they did see it. They were deeply traumatized by it. They feared for their families. That is harm. It's not just reasonably apprehended, it's actually caused. So with respect, I don't believe that the Kwelane judgment assists Mr. Garvey in any of the respects that he seems to think it does. And That is all I would wish to say in respect of the fourth respondent in reply.
Yes, thank you. Advocate Garvey, you heard me mention issue about the costs issue. Would you want to respond to that? You also asking for cost on an attendant client scale. I take it you also say that must include council's fees. Am I right?
Yes.
Yes. But with them,
I'll wait for the submissions and then we'll respond to those submissions.
Right.
I don't know when the timeline is. As I said, I'm not available from tomorrow, so I'll be available in the new year again. So that's, I don't know, perhaps Mr. Ismail can give an indication what his timeframes are like.
Yeah, when in the new year, are you able to give us a date when you are back in chambers? I know not
15th, that 17th, I think. 10th to 17th.
Justice Makume,
Yeah,
perhaps I can.
17th.
Just hold on. Just hold, let me. Advocate Garvey says he's back on the 15th of January. Maybe because it is the complainant who must first file the replying heads, and then I think Advocate Garvey will only be able to respond there to after the 15th of January. Am I right?
Justice Makume, perhaps I can resolve that debate very quickly.
Yes.
We will make a submission on costs right here and now so that it's not left over for any reply. I don't want to trouble Advocate Garvey on his holiday. What we'll submit to you is that we would request the costs of 2 counsel.
Okay.
And Advocate Garvey can then deal with it right here and now. Insofar as Advocate Garvey seeking attorney and client costs, that wasn't his submission before you. His oral submission was that he sought costs on a party and party scale. I'd identified that it was at odds with his written submission in paragraph 60 something. And I pointed out that he had climbed down from his position, no doubt, after the 4th and 8th respondent had seen the full scope of their conduct as set out in our heads.
Okay. Very well then, gentlemen and lady, thank you very much for your submissions. It brings us to the end of this matter. I'll await the further supplementary heads in respect of the reply. And Advocate Garvey will also then make his submissions on the request for counsel and attorney client scale, which will include 2 counsel. When do, I mean the timelines, complainant, when do you think you'll be in a position to have filed?
Justice Makume, I'm struggling a little to understand the role of the 4th and 8th respondents in filing heads on costs. They have seen our heads on costs. They have heard our submission on costs. There's nothing more for them to do in relation to that.
Okay, now let's concentrate on your reply, your response to the 4th respondents heads, where you have left out some things. Are you able to give me an indication when you'll be able to file?
When would be most convenient for you, Justice Makume? We'll try and work around that.
No, I'm only going back during the week of the 13th of January. That's the only time I'm back in chambers. Back at work from I'm on long leave in any case, so I've made myself available for this matter because I want to have sufficient time to be able to sit down and write a judgment. Yes. But if you can give me your responses and serve on Advocate Garvey, and then I can be able to sit down and write a judgment.
Certainly. Can we then propose, given the looming holiday period, can we then propose the 15th of January to get our submissions on?
Okay, that's fine. 15th of January 2022, your response to the 4th and 8th respondents heads of argument, insofar as you have not dealt with the issues some of the issues that were not raised. Okay.
Thank you, Justice.
Thank you. Advocate Garvey, you want to say anything? Advocate Garvey?
My Lord, No, I just wanted to point out when I was looking at the calendar, I see the 15th is a Saturday. I don't know. I think probably the 17th is the date that Mr. Ismail had in mind.
Yeah, the 17th should do. Okay.
Thank
On
you.
that basis, thank you very much,
As a
gentlemen.
court,
This brings us to the conclusion of the matter, and court adjourns at this stage. I thank you very much for all your submissions today. Thank you.
As the court pleases. Thank you for your time and consideration, Justice.
Thank you.
as a court, please.